Mart, you're up.
Thank you, Chair Mitchell. Good morning, panel. My name is Carrie Grunman on behalf of Walmart. I have a couple of questions that I think are predominantly for Mr. Roberts, and I hope it's just a couple of questions. Yesterday, in response to some questions from counsel for Avangrid, I think you indicated that the sort of preliminary results from the NCTCP weren't sufficient to sort of evaluate the location for interconnecting offshore wind, and that an actual interconnection study needed to be conducted. Is that fair?
Yeah, I would say that the NCTPC offshore wind study results are directionally correct. However, in order to know the true network upgrades that need to be constructed for injecting a certain megawatt level, you would have to put in an interconnection request into a DISIS study.
And that by network upgrades, you mean any upgrades, network transmission, sort of all of the above, what would be necessary to interconnect that particular project?
Yes, that's correct.
Okay. And is it fair to say that of the 3 parcels of offshore wind off the coast of North Carolina, that none of the 3 of those have entered DISIS in 2022?
That is correct.
And the earliest they could enter would be January 1, 2023?
That's the next DISIS enrollment window.
And so whether it is the Avangrid, Total, or Duke affiliate facility, at this point in time, the company does not know definitively the costs associated with interconnecting any one or more of those particular parcels of offshore wind.
Right. Based on using the NCTPC study as directionally correct, saying New Bern is the preferred point of interconnection. We have conducted internal analysis to look at what it would take to interconnect to New Bern. And those numbers were provided in a data request comparing that against other points of interconnection.
And when you studied that connecting to New Bern, did you study that based on one particular parcel of land?
No.
Thank you, sir. Those are all the questions that I have.
Morning, Ms. Barber, Mr. Roberts. I'm Robert Josie with Public Staff. Let's stick with offshore wind for a moment. Mr. Roberts, you were just discussing the need for a DISIS interconnection study for the wind projects. Is Duke anticipating studying requesting a point of interconnection in New Bern at this point?
That's correct. We have it in our near-term action plan to submit a generator interconnection request with the point of interconnection being New Bern.
And I believe you said yesterday that interconnecting into New Bern would require the transmission line from New Bern to Raleigh to be upgraded from a 230 kV line to a 500 kV line. Is that right?
So based on an informal analysis, no. I mean, it depends on the megawatt level. So if you're looking to connect, this is what we had in our stakeholder meeting on one of the slides. I believe it was the March stakeholder meeting, that if you want to connect 1,600 megawatts of offshore wind into New Bern, you would need a 500 kV line.
Okay, so if it's just Duke Energy requesting interconnection into that line for an offshore wind facility, then it may not need to be upgraded from 230 to 500. But if either of the other potential facilities were to request interconnection there, it would need to be a 500 kV line.
Objection, Chair Mitchell, is Mr. Roberts' testimony doesn't really get into the different parcels and amounts of those.
I think it's common knowledge and been testified at this point how many megawatts are looking to interconnect into that particular point of interconnection based off of the 2020 NCTPC study.
All right, I'm going to overrule the objection. Ask your question again so that he may answer it.
I'll ask it another way. If there were more than the 800 megawatts of offshore wind looking to interconnect into the New Bern substation, would that line need to be upgraded from 230 to 500?
Yeah, I mean, based on informal analysis, and looking at the results of the 2022 DICES, where some of the solar is requesting interconnection. If a lot of that solar interconnects, then you could possibly need a 500 kV line above that amount.
And just because you touched on the solar that could possibly interconnect to that line in the 2022 DICES, that line is outside the red zone currently, correct?
That's correct.
And if the line were to be upgraded from a 230 to a 500 kV line, is that completely rebuilding a new line, or is that considered an upgrade?
Yeah. So what we're reflecting and reflected in the stakeholder meeting and in Appendix P is that you would need a new 500 kV line for which we already have substantial right of way. But it would be a new 500 kV line from Newbern to Womack to Wake.
Okay, and do you know if building a new 500 kV line along that corridor would require a CECPCN by this commission?
So I think it would require a CPCN or CEPCN. I mean, you're gonna most likely have to require a right-of-way extension for a portion of that 500 kV line.
Okay, thank you. And to your knowledge, do you know if Duke Energy Renewables, who owns the facility at this time, or owns the lease parcel, intends to enter into the 2023 DICES?
I'll defer that to the long lead team.
But there's nothing stopping Duke Energy Renewables from submitting an interconnection request.
Not to my knowledge.
And if this facility were to enter into the 2023 DICES, what would be the requirements for it to continue through the study process and remain in the baseline in order to reserve its spot for the capacity on the line?
Chair Mitchell, could council clarify which this facility
The
refers to?
Duke facility.
So you're saying if Offshore, the Duke Energy Renewables submitted a interconnection request to the 2023 DICES, how would it retain its location or spot?
It's spot in the queue process in the baseline for future DICES studies. I think we've heard testimony to this point that states that it's going to take a while to build this facility.
Yeah.
So if it enters the study process,
Ms. Barber's more familiar with the DICES process.
So subject to check, to maintain eligibility in DICES, there are different requirements for phase 1, phase 2, and beyond. One of the ways that you can demonstrate readiness is to put down deposits. And so because it would be FERC jurisdictional, it could meet the eligibility with deposits along the way.
Okay. And would it need to interconnect within a year or two after the study process is complete in order to remain in the baseline?
I would want to double check this, but I believe once the interconnection agreement is signed, that stipulates the timeline for when it would interconnect. And then there are requirements and milestones associated with that.
Any necessary upgrades resulting from the study and postulated in the interconnection agreement would have to be complete before it could be commercial.
Okay, and is there a suspension provision in the open access transmission tariff that would allow it to wait?
I believe there is a suspension provision for FERC jurisdictional projects, yes.
Thank you. And I believe this is for Mr. Roberts. If DEP were to own the offshore wind facility and run an underwater transmission line to the point of interconnection in New Bern, would that underwater line be subject to DEP's open access transmission tariff, allowing other, well, answer that question first.
Yeah. So the submerged cable, I can let the long lead time speak more to that, but I'll just go on record as saying it's longer coming from one lease area than it is from the other, based on the New Bern point of interconnection. But once you get to the landing, there's what we call onshore interconnection facilities, transmission line that needs to be built to get from the landing to New Bern. And so that would be part of the interconnection facilities. So that would be the responsibility of the generator owner.
Okay, but I guess my question is that line from the offshore wind facility itself, if it is owned by Duke Energy Progress, is it subject to open access transmission and therefore interconnection into that line from other facilities, like any other part of the grid?
Right. I'll let the long lead time groups speak to this. I'll defer the question to them. The only thing I would offer is that the interconnection facilities can be one submerged cable, it can be two submerged cables, it can be three submerged cables, depending upon the megawatt level. And to get from the landing to New Bern, you're going to have high voltage DC as part of those interconnection facilities. But once again, that's part of the facility study for determining the interconnection facilities required. And it's also the responsibility of the generator owner.
Okay, so you're saying you're not sure whether or not another facility such as Total or the Kitty Hawk project by Having Grid could interconnect directly into the line from the facility, from the Duke's offshore wind facility,
Right.
in between those point of interconnection.
Yeah, once again, I'll defer to the long lead time group. They'd be more familiar with that. But that submerged cable is not part of the revenue requirement associated with our transmission tariff, if that answers your question.
All right, thank you.
Oh, I was just going to ask,
Okay.
is the question to determine where the demarcation is between interconnection facilities and the network?
Yeah, the point of the question is to try to figure out whether or not any DEP-owned transmission line is subject to an open access transmission tariff, allowing other facilities to interconnect to it,
Okay.
just like any other transmission line on the system.
No, it's not network transmission. So it's not governed by our tariff with respect to our revenue requirement. It is governed by the LGIP process and the interconnection facilities piece of that.
All right, thank you. We'll switch topics to off-system purchases. You stated on page 59 of your testimony that Duke and PJM studied the possibility of a 1,500 megawatt firm transfer from PJM to DEP at an estimated cost of $700 million. Is that correct?
That's correct. We coordinated with PJM, used their PJM generation deliverability tool, used their data, and that was a piece of the study. We also looked at affected system studies that have been done, and we looked at the NITS, or Network Integration Transmission Service piece, the network upgrades on the DEP side that wouldn't be needed. And based on that analysis, we got to $700 million projects, and I'm subject to check. I believe it's around 84 months to construct the upgrades.
And the upgrades for that transfer, would they be partially on PJM's transmission system as well?
Yes.
Okay. And would Duke Energy ratepayers be responsible for paying those costs?
So my understanding, subject to check, is that PJM can charge a special rate with respect to those upgrades, or they can charge their border rate for point to point. And I think we show in Appendix P that order rate keeps climbing. I think we assumed 5% per year, but it's more than that. But that border rate keeps on increasing as they keep on building transmission in their system and incorporating that into their border rate. And so we would have to pay that border rate. So for example, 1,000 megawatts at the 2021 rate, I believe it is, would be 67 million per year.
And that money recovered by Duke Energy ratepayers would be to improve the PJM grid, correct?
Yes, I mean, it would improve the PJM grid, but you're improving that grid to be able to import 1,000 megawatts.
And is, Mr. Roberts, are you aware of Duke Energy Progress's intentions to upgrade the Greenville-Everett's line?
Yes,
And is that a part of this plan?
no, that is
No,
not a
that's
part of
separate.
it. Separate.
And for the off-system purchases, such as the onshore wind or any purchases that may come through these tie lines that we were just talking about, were they given a transmission cost adder or proxy?
So yes, we actually took the border rate and converted that to $1 per kW year, and once again escalated that in time based on past increases. PJM have been charging for their border rate.
And those off-system transmission cost adders, they include the wheeling fees as well for the off-system purchases.
So that border rate would be the wheeling fee, and then you got the cost of the resource. You know, Duke Energy is going to own the resource in Ohio or somewhere. You know, you got that cost as well. But modeling team could speak to that.
Okay. And if Duke Energy were to have to own onshore wind in the Midwest, MISO, for instance, it would have to pay wheeling charges for MISO and through PJM to get it to the Duke Energy grid.
That's correct.
Okay. And so when we're talking about the cost adders, the transmission cost adders, and comparing on-system purchases to off-system purchases, it's not really an apples to apples comparison, is it?
That's correct. It's not.
Thank you. Okay, I have a couple questions about the red zone upgrade projects. Is the RZEP projects, they're considered local transmission projects, is that correct?
That's correct.
Okay. And that's why Duke Energy is proposing them through the NCTPC process.
That's correct.
And you mentioned on page 22 of your testimony that the RZEP projects will be subject to the attachment N1 planning process, correct?
That's correct.
And that's an attachment to Duke Energy's joint open access transmission tariff.
That's correct.
And section 4 of attachment N1 states that the local transmission plan will identify local transmission projects or local projects. And a local project is defined as a transmission project that is one, located solely within the combined Duke Progress, I assume that means Duke Energy Carolina's Duke Energy Progress, transmission system footprint, and two, not selected in the regional transmission plan for the purposes of regional cost allocation.
That's correct.
Okay. And so did the RZEP projects, did Duke Energy request selection in the regional transmission plan at CERTEP?
No, we didn't. If those projects get included in the NCTPC local transmission plan, they would automatically flow into the CERTEP model.
But as I read how section 4 of attachment N1 reads, if I read it correctly, it has to go to CERTEP first and not be selected as a CERTEP project before it comes to the NCTPC.
That's not my understanding of how the local transmission planning process works in accordance with attachment N-1.
Okay, and subject to check, section 7 of attachment N1 is the transmission cost allocation for local projects. But it only provides cost allocation methods for joint local reliability projects and joint local economic projects. Is that correct?
Subject to check.
Chair Mitchell, can we ask if the witness needs a copy of N1?
Chair Mitchell, at this time, I would ask to enter into evidence and mark for identification, public staff transmission panel direct cross exhibit 1, which is excerpts from the joint open access transmission tariff of Duke Energy Carolinas, Duke Energy Florida, and Duke Energy Progress.
All right, hearing no objection, I'll allow y'all to, we'll get it entered into the record, but can you give it to council first, just so they can look at it and make sure, since it's excerpts, before you hand it on to the witness? And council for Duke, when y'all are okay with it, please just give me a signal.
Looks okay to us.
Okay.
What?
All right, the document will be marked for identification as public staff, transmission panel direct, cross-examination, exhibit 1.
Chair Mitchell, can council clarify that this came from the Oasis site?
Yes, it was downloaded from Duke Energy Progress Oasis website.
Mr. Josie, on what date did y'all download it? Do you recall?
I do not recall.
Time frame, would it have been within the past week or 2
I
weeks
would
or
say in the past several months.
several months? Okay.
It's been on my desktop for a while.
Okay. All right. The witnesses have had a chance to look at it. Mr. Josie, please proceed.
Mr. Roberts, if you could flip to the last page of the excerpt I gave you, and this is just section 7, as we were talking about, discussing, titled Transmission Cost Allocation for Local Projects. And section 7.1 says, with the exception of joint local reliability projects and joint local economic projects, nothing in this attachment is intended to alter the cost allocation policies of the tariff.
That's what it says.
Yeah. And so are the red zone upgrade expansion plan projects, are they considered reliability projects or economic projects?
They're considered generator addition projects / public policy projects.
Okay, and so there is no specific cost allocation method for these projects contained within this attachment.
Within this attachment, no, but as far as, it says will not alter the cost allocation policies of the tariff. That means that they would be allocated as any project that goes into the base plan.
And any project that goes into the base plan for DEP or DEC is allocated wholly to either DEP or DEC.
To the transmission owner. That's correct.
Yes. Okay. And so to your knowledge, there's no ability for Duke to allocate cost of these projects across DEP and DEC.
I believe the panel that Ms. Bateman and Mr. Peeler were on spoke to that. But to my knowledge, today, there is no cost allocation methodology to spread those costs across DC and D.
Okay. Thank you. Okay. As far as the determination, Duke's determination for projects that it included in the red zone expansion plan, was there anything other than the amount of study request or interconnection request into each line that went into the evaluation of whether or not to put those specific projects in the plan?
Yeah, so I'll go through a little bit of a history because I think it's important. Back in the 2021, I believe it was October timeframe, technical conference on the 2020 IRP. That's when Duke first introduced. Yeah, we made a great stride with respect to this DICES process, this first ready, first served process and cluster studies. And this will help manage an efficient queue going forward. But it was also pointed out that even though it distributes cost allocation among multiple projects versus the serial queue was the first to cause, you still can have issues with respect to insurmountable network upgrade hurdles that developers don't want to finance or can't meet a certain cost number, et cetera. And so they withdraw. And that's exactly what happened in the transition cluster study for DEP is I think you're down to 100 and subject to check, around 180 megawatts of projects now, 2 projects. So, you know, exactly what we thought would happen or could happen happened with that transition cluster study. And so in that 2020 IRP technical conference, we also showed a map and we showed these are common hurdles that are creating inefficiencies with getting generators, solar to interconnection, to an interconnection agreement. And we're going to have to address those. And we need to address those with a proactive transmission planning process. And that's, you know, long story short, that's exactly what we're trying to do with the RZEP projects. And the mechanism that FERC has approved to facilitate such projects, getting them into the base plan, is through the NCTPC.
Okay, and so as you were just stating, there were multiple interconnection requests into these areas. They were unable to interconnect due to the large interconnection cost. And so that is what Duke Energy looked at in determining which projects would go into the plan.
It's knowing with the 2020 IRP portfolios, all the magnitude of solar that were in those portfolios, the magnitude of solar in the carbon plan, you know, that factors into that. And if you do nothing, other red zones are going to be created and you're going to have issues in other areas with red zones, congestion. And so what we did was we looked at what are the most common upgrades that are being hit by these solar projects requesting interconnection. And so that was our initial mapping that we did of studies versus red zone projects. Then we went one step further and you know, through communications with public staff, we agreed on a scope and we conducted a supplemental study of 5.4 gigawatts of solar, 1,900 in DEC and 3,500 in DEP.
The public staff appreciates that supplemental study. But, and I think it should be made clear here that it is the ratepayers that will ultimately bear the cost, either from the interconnection upgrades due to the 2022 solar procurement or the red zone upgrades, correct?
Yeah, all transmission customers will share in the cost.
The transmission customers will, well, transmission customers as in wholesale and retail, correct?
That's correct.
Okay. So when Duke Energy is looking at including a project in this red zone expansion plan or any future red zone expansion plans, is there any cost that would be prohibitive to including it in the plan?
Right. So as provided, cost benefit in testimony, cost benefit analysis was done. And we used the asset management model, and it showed with the age of these assets and probability distribution associated with, the likelihood of impacting customer outages, that there was a positive cost benefit. And that's just one area. It didn't consider the renewable benefit, the clean energy benefit associated with what these projects would provide. And I think I stated yesterday in live testimony that these red zone projects should facilitate larger projects, solar projects interconnecting to the system. And that has a cost benefit as well. Or excuse me, a benefit, net benefit.
And as you just stated, and as you stated, I guess you stated yesterday that there will be need for more upgrades in the future on top of this red zone expansion plan. Is that correct?
That's correct. We look at this as the first phase, and but the first phase, but a necessary phase with respect to executing the carbon plan.
Okay. And will Duke Energy consider whether a line has been recently upgraded in the past in determining if that line should be upgraded again, or will it only consider the number of interconnection requests that are submitted for that line?
Right. I think this was covered yesterday in live testimony as well, in that based on the transmission planning engineer's judgment and standard conductor, standard poles, etc. I think I referenced the Cape Fear West End line, where we would go from a single conductor 1272 CML to a bundled 1590 CML, and thus increase that MVA carrying capability by 121%.
And again, you may have stated this, sorry if it's been is asked again, but does Duke consider the red zone projects to be necessary for reliability purposes?
So to reliably deliver the solar to load centers, yeah, I mean the ultimate beneficiary are the customers, right? I mean, if you have to curtail the solar to manage power flows, that's not executing the carbon plan, and it's not benefiting customers to build a resource that they can't be served by.
And so while Duke Energy is presenting the red zone expansion plan as public policy projects, they could be considered reliability projects as well.
Reliability in the sense of firm deliverability of that resource to the load, yes.
And you're generally aware that Duke Energy is considering merging the balancing authorities between DEP and DEC.
Yes, that's Mr. Peeler and Ms. Bateman spoke to that.
And could that possibly alleviate some of the need for these red zone upgrades?
I would say no. And given the transmission system, if you connect solars in those areas, you're going to hit those specific red zone projects with respect to an increase in line loading where contingency overloads that line.
But has it been studied? Has Duke Energy done a formal study to determine interconnections when looking at both DEP and DEC balancing authorities as one?
We've discussed that, with respect to interconnecting resources, and only when you look at things like if you had all the solar in DEP, for example, or you had all new replacement generation or a large portion of replacement generation in DEC, and you need to get that to load in DEP. Only in those situations would you need to look at more capability between the systems, being implemented between systems. Now, I'll give you an example. So if we retired Roxborough plant and we didn't replace that generation on site, and we located the replacement generation in the DEC area, even if we're merged, we would still probably need to build, well, I would say we will need to build some transmission to get that generation from that legacy DEC area over to the legacy DEP load. And it would probably be, I think, I referenced this in the Appendix P. It would probably be in the form of a new 230 line, a new 500 kV line, and a new 500 to 230 kV transformer station.
And so that would be on top of the red zone upgrades, on top of the interconnection or the upgrades needed to bring in off-system purchases, and on top of the upgrades for the wind facilities.
That's correct. However, that's one of the reasons we're promoting proactive transmission planning in this testimony is that we've got to look at all that holistically. And then there's going to be some assumptions made about where replacement generation is going to be located that will impact that transmission as well.
Thank you. And so as this red zone expansion plan goes through the NCTPC approval process, could you just give a quick narrative of how that's going to proceed if the commission were to acknowledge?
Yeah. So in a parallel path, we're going to present the results of the supplemental study, how we conducted it, et cetera. We're going to present that to the TAG and subject to check. I think that meeting is around October 19th or 9th, maybe 9th, subject to check. But anyway, at the next TAG meeting, at the next TAG meeting, we're going to present the supplemental studies and the results and, receive feedback. And then ultimately, hopefully we will get to December, have that in the annual local transmission plan, and then have the OSC vote on that. The TAG will get to review the draft report, provide feedback, and then a final report will be issued in January of next year.
And when you say the final report, that's from the Oversight Steering Committee, not the TAG, correct?
With TAG input, yes.
Yes, with TAG input.
That's correct.
My understanding from your discussions with other parties yesterday is that TAG is basically, or the Transmission Advisory Group is basically the place for stakeholder input, which then is taken to the Oversight and Steering Committee, which then votes on whether or not to approve the local transmission plan. Is that correct?
For the most part, that's correct.
And are you currently on the Oversight Steering Committee or OSC?
Yes, I am. I would not be the primary voting member then.
Chair Mitchell, at this time, I'd like to introduce and mark for identification public staff transmission panel direct cross exhibit 2. And this is the scope document for the Oversight Steering Committee. Thank you.
here. All right, we will label the document for identification purposes as public staff, transmission panel direct, cross-examination, exhibit 2.
Okay, Mr. Roberts, could you, I mean, I guess first of all, this does appear to be the scoping document that kind of determines how the Oversight and Steering Committee proceeds in its process.
Yeah, I mean, I will state on the record that the FERC-approved governing process is in our oath in attachment N-1.
Correct. So this is basically regurgitated in the oath, or was pulled from the oath.
This should be reflective of the oath.
Great. And on the back page, this is just a list of the people on the Oversight and Steering Committee as of yesterday, September 19th, 2022.
That's correct.
Was there a meeting yesterday?
I believe there was. I did not attend it, though.
I was going to say you're a busy man. Okay, and so on page 2, under the heading membership, it states that the OSC will consist of 8 appointed members plus ex officio members as approved by the OSC. And Duke Energy Carolinas, Duke Energy Progress, Electricities, and NCEMC shall each appoint 2 members to the OSC and may appoint up to 2 alternate members.
That's correct.
That's correct. Okay. So Duke Energy has half of the members, the voting members for the OSC, correct?
That's correct.
On page 5, under voting, it states that members of the OSC shall use reasonable, good faith efforts to reach decisions via consensus. However, in the event that the OSC is unable to reach a decision by consensus, then a decision will be reached by a majority vote, correct?
That's correct.
Has the OSC ever not reached a consensus, to your knowledge?
I mean, I don't have a long history with the NCTPC. In the history that I do have, I have not heard of not reaching consensus.
And so, and to your knowledge, Duke Energy Progress and Duke Energy Carolinas have never voted in opposite directions on a plan. They've never conflicted.
Like I said, with my history, I've not noticed that NCMC, Electricities, Duke Energy Progress, and Duke Energy Carolinas have not voted consistently.
Okay. And to your knowledge, do you know it? Well, to go down a little further, it says that in the event of a tie vote, the OSC shall retain an independent third party who will provide a recommended decision based on a review of the issue in dispute. You see that?
Yes,
Okay. Are you aware? I mean, you just said that you're unaware of any vote that was not a consensus, so I assume you are not aware of any time a third party has been retained to.
based on my limited history, and my understanding is there's always an independent entity that administers the process for the NCTPC.
Okay. And then down in the next paragraph on page 6, middle of the page, it says, it is anticipated that all parties will abide by the decisions of the OSC. However, any NCTPC participant or tag participant may request that the North Carolina Utilities Commission public staff render a non-binding opinion with regard to any disputed decision of the OSC and any decision of the investor-owned utilities superseding a decision by the OSC. And to your knowledge, that's never taken place either, correct?
Not that I'm aware of.
And sorry to jump around a little bit, but we'll go back up to the top paragraph on page 6, on the second line where it starts. However, the investor-owned utilities shall not be bound by decisions of the OSC to the extent that the investor-owned utilities reasonably determine such decisions as related to reliability planning, and that are inconsistent with good utility practice or CERC or NERC established criteria or least cost integrated resource planning principles. Is that correct?
That's what it reads.
And so if Duke Energy determines that the red zone expansion plan projects are necessary for reliability purposes, whether the OSC agrees with them or not, Duke can go ahead with those upgrades, correct?
So I think that what this is referring to, usually when we talk about reliability projects in the NCTPC world and in the Duke Energy transmission planning world, we're talking about projects resulting from TPL-001 NERC standard studies. And so those projects are projects required by the standard to be implemented to meet those reliability standards.
Thank you. And just a few more questions I think this one could be for either of you. The projects that are in the DICE process right now, do you know the percentage of transmission projects to distribution projects?
Off the top of my head, no.
Would you say there are more transmission projects than distribution projects?
Megawatt wise, definitely. But number wise, yes.
Number wise, yes, there are probably more
Transmission connected projects.
connected projects. Okay. And did you hear the line of questioning Mr. Kalimba answered on interconnection limits last week, stating that the Duke limits, Duke is imposing are based off historical annual interconnections?
That was one of many reasons for the interconnection limits.
Okay. Those historical interconnection limits were mostly based off of interconnecting small 5 megawatt projects onto the distribution system, correct?
Yeah, I believe, or recall correctly, one of the interveners spoke to connections in 2015 and 2017 interconnections, and a lot of those interconnections were distribution connected resources.
So understanding that the transmission interconnections are more complex, but interconnecting 750 megawatts of mostly 5 megawatt facilities would be substantially more facilities than interconnecting, 70 to 80 megawatt or more facilities, correct?
And it's going to take you a very long time to get to 70%.
So, okay. But all to say that you're connecting fewer facilities to get to 750 megawatts when you're talking about 951 projects that are mostly transmission interconnection projects, correct?
Yeah, and that's another benefit on projects is that you're enabling interconnection in areas where you can have larger solar facilities. So for a given number of interconnections, you can connect more megawatts.
Okay. And Mr. Roberts, you stated in response to a question from Mr. Burns yesterday that the NCTPC process updates future generation resources in its base analysis. Is that correct?
So I believe he asked about generation additions and retirements, or I answered with generation additions and retirements. But yeah, so generation addition that and resulting transmission network upgrades that have resulted from IAs, those are in the base reliability plan, just like proposed projected generation retirements. If they're in an approved IRP or an approved carbon plan, that's studied in the base reliability model in NCTPC.
Yeah, so as you just stated, if an IRP calls for a resource, the NCTPC will include it in its analysis. Is that correct?
Well, so if the IRP calls for a resource, if the location is known and the point of interconnection is known, then in megawatt size, then yeah, it can include it specifically in the model. But if it's like look at 2,000 megawatts of additional solar, then some assumptions have to be made as far as location and size.
And the NCTPC released a study scope document a few months ago. Is that correct?
Subject to check, yes.
Yeah, okay. We'll get there. This time, Chair Mitchell, I would like to present and have marked for identification public staff transmission panel direct cross exhibit 3, which is the 2022 NCTPC study scope document.
Okay.
Yeah. I just gave her my two. Hold on.
All right, the document will be marked for identification as public staff transmission panel direct cross-examination, Exhibit 3.
Mr. Roberts, could you flip to page 5 of this document, please? And is this, according to this page, the study scope, it includes 2 Roxborough combined cycle plants totaling 2,700 megawatts
That's correct.
in the 2032 to 2033 W
Yeah.
column. Okay.
Yeah, the winter case.
And so if you're generally aware that the public staff had to run a SP5 model
Yes.
for this proceeding, and that those 2 combined cycles in that model were not at the Roxborough location.
That's correct.
Okay, so how would the NCTPC process update facility additions or subtractions that are called for in the commission's approved carbon plan, particularly if it didn't have these facilities in that location?
Right. So what you're seeing here is reflective of the current plan. These are actual solar interconnections that are included. You can see in 2027 summer case. And so Roxborough CC, if the carbon plan that's approved says 2,700 megawatts, the CC and DEC were meeting DEP resource planning requirements, then once again, you're talking about some substantial transmission and greenfield transmission, and even these 2032, 2033 dates would be challenging.
And I assume you're familiar with the Southeastern Regional Transmission Planning, or CERTEP?
Yes, I'm not a member of that group though.
And do you know if these 2 combined cycles at Roxborough were also presented to the CERTEP at the same location?
I do not.
Okay.
That file was recently submitted back in August, I believe, to CERTEC.
Okay. I believe this is from Ms. Farber. Last question. does Duke believe its petition to separately acquire CPRE capacity through the 2022 solar procurement will result in lower cost to ratepayers,
Lower cost as opposed to what?
as opposed to just including them as acquiring them all through 951 like every other project?
Thank you. I am not sure that there's going to be a cost difference as to whether or not megawatts are tagged as CPRE versus 951 megawatts. They're still part of the same bid process. They have the same contract structure, duration. So I don't see a difference in the price, but since we still have an outstanding legal obligation to fulfill the CPRE target, that was, the motivation for proposing it. Excuse me. That was the motivation for seeking those megawatts through the bids that have already been received for the solar procurement.
Okay, thank you for that. No further questions.
All right, redirect.
Yes, thank you. Mr. Roberts, in your testimony yesterday, do you recall when counsel for tech customers asked you some questions about coal retirement?
Yes.
And how much coal generation capacity are the companies planning to retire by 2035?
Yeah. So as reflected in my testimony, I believe it's table 1, a little over 8,400 megawatts of winter capacity is planned to be retired by 2035.
And what are the implications of those retirements from a transmission perspective?
Yeah, so from a transmission perspective, some of this has been discussed, but if you can replace the resource on site, then and it's similar capability, then you're likely not to have transmission impact. In fact, the generation replacement process, that's part of the independent entity study, is to show there's no material impact to the transmission system with the replacement generation. If you don't replace it on site, and we may see that the most cost-effective solution is not to replace it on site, but then there's the timeline issue. For example, if you can't replace Roxborough on site and you have to build greenfield transmission, i.e. 500 kV line or new 230 kV line or new 500 230 kV substation, transformer station, then that can add significant time to getting that replacement generation in place and being able to facilitate the retirement. And then there's going to be local impacts as well. For example, if you retire Roxborough, you're probably going to need some substantial static bar compensator in the area.
All right, thank you. And then also yesterday, counsel for CPSA asked you some questions regarding the time required to interconnect solar projects. Do you recall that?
Yes.
And he asked whether you agree that a project that does not need thermal upgrades could connect in 1 to 2 years. Do you recall that?
Yes.
Upon further reflection, do you still agree with that suggestion?
No. So reflecting on that, I did not agree with 1 to 2 years. And I think witness Kalimba discussed this as well in his testimony, but it's really around 26 to 32 months now. But we are looking to improve that process associated with getting the IA to getting COD.
And then to follow up on that topic, you also had some questions about Duke's engagement with developers to improve the solar interconnection process. Do you recall those questions?
Yes.
In your view, has Duke already achieved significant amounts of solar interconnections to date?
Yeah, absolutely. We've connected over 4,000 megawatts of solar, and we have 1,600 under construction. So we're nation leaders associated with interconnecting solar. So I'm kind of proud of the amount of solar we've been able to connect over the last several years since the state tax credit.
And even with that success, is Duke doing anything to improve in this area?
Yes, like I was saying, we conducted some process improvement events, and through those process improvement events, we assigned actions to different groups, such as engineering, looking at the engineering standards associated with the interconnection facilities, And they're running with that and looking to improve those standards so that you can get that done in a more efficient manner with respect to constructing interconnection facilities. We're also looking at the standards. If you have a cookie cutter approach with respect to these interconnection facilities, that can present efficiencies as well. So there's several facets between getting the interconnection agreement to COD with respect to the interconnection facilities that we're looking at with gaining efficiencies. And our target is aggressive targets, 20 months.
Okay. And when does the company plan to launch some of those efforts that it's been developing?
In 2022,
Okay.
this year.
That's right. 22 is this year. Thank you. Council for CPSA also asked you some questions about the results of the supplemental studies for the red zone. Do you recall that?
Yes.
And in your testimony, you testify that both STEC and DEP study results reflected that the red zone projects were needed to enable about a total of 3,700 megawatts of projects to be interconnected. Is that right?
That's correct.
And by saying that the red zone projects will enable solar project interconnections, do you mean that if the red zone projects are done, Duke can go out and automatically interconnect those projects without any other upgrades?
No, I'm not saying that. So once again, these are common upgrades that a lot of generator interconnection requests have basically reflected overloads associated with these transmission lines. And because they're common to so many megawatts of solar requesting interconnection, it makes sense to go ahead and get these constructed in a proactive manner. And so there will be other upgrades needed. Even the ones we evaluated in the supplemental studies outside the red zone are probably going to need network upgrades. But also inside the red zone, there could be additional upgrades that are needed based on size and location of the solar that's requesting interconnection.
Thank you. Just a couple questions from today. Council for the Public Staff handed out the cross exhibit to the Transmission Planning Collaborative OSC scope document. Do you have that?
Yes.
It's the one with the list of the roster on the last page.
Yes.
Would you agree that 4 of the 11 people listed on that list are Duke personnel?
Yes,
Okay. There's also 3 NCEMC personnel, correct?
that's correct.
And 3 electricities personnel, correct?
That's correct.
Okay. And Council for the Public Staff also asked you about a couple questions about the solar interconnection abilities that Duke has included in the plan for the 750 megawatts.
Yes.
And he mentioned that in the past that was based on historical projects that were many more projects of much smaller size. Do you recall that?
Yes.
Could you explain why a fewer number of projects that are larger in size is much more complex to implement?
Yeah, so the interconnection facilities themselves, if they're connecting to 230, there may be a ring bus that's needed associated with that. That could take a little more time. Line switches on 115 are needed. But outages in general for transmission projects, all of those outages have to be coordinated. And it's not just interconnection outages, interconnection facility outages, or network upgrade outages. You've also got maintenance outages. You've got asset management program outages. You've got unplanned outages. You've got NERC preventative maintenance required outages or relay maintenance, et cetera. So there are a lot of things that have to be considered with respect to these facilitating these interconnection facilities.
Thank you. No more questions.
All right, the commission's going to defer questions for the panel to a later time. So with that, I'll take motions, and as we're taking motions, you all may step down.
Chair Mitchell, the company moves that companies Move the panel's exhibits 1 through 5, with Exhibit 5 being marked confidential, to be accepted into the record at this time.
All right, hearing no objection, that motion's allowed.
And just to be sure, I'd like to also move that the summary of this panel's transmission summary of testimony be admitted to the record at this time.
It'll be copied into the record as if given from the stand. All right, Mr. Josie.
Thank you. Chair Mitchell, at this time, the public staff would ask that public staff transmission panel direct cross exhibits 1, 2, and 3 be entered into the record.
All right, hearing no objection, your motion is allowed.
Madam Chair, CCBA at this time would move to that CCBA transmission panel direct cross exhibit 1 be admitted into evidence.
All right, motion is allowed.
Chair Mitchell, at this time, SIGFOR 2 and 3 would move that its transmission panel direct cross-examination exhibits 1, 2, and 3 be entered into the record.
That motion is allowed.
Thank you.
Chair Mitchell, at this time, Avangard Renewables would move to enter Avangard Renewables LLC transmission panel direct cross-examination witness exhibit number 1 into the record.
All right, your motion is allowed. All right, Duke, call your next witnesses.
Thank you, Chair Mitchell. For the record, my name is Vishwa Link, and Duke Energy calls the long lead time resources panel to the stand.
Gentlemen, if you would, raise right hands, left hand on the Bible. You swear testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right. All right, whoever is sitting in that last chair, please make sure you got the microphone on, and just be cognizant that you need to be facing towards the mic when you speak so that everybody in the room can hear you. Thank you. And hold it get as close to the microphone as you can. All right, go ahead, proceed.
Good morning, gentlemen. Beginning with Mr. Repka, would you please state your full name and business address for the record?
My name is Regis Repko. I am the Senior Vice President of Generation and Transmission Strategy. My business address is 526 South Church Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy as the Senior Vice President of Generation and Transmission Strategy for Duke Energy Carolinas LLC.
And can you please briefly describe your role and responsibilities at Duke Energy?
I'm responsible for the execution planning, the technology determinations, and the procurements for generation, transmission, and fuels to meet Duke Energy's clean energy transformation goals.
Thank you. Moving on to Mr. Immel. Would you please state your full name and business address for the record?
Yes. My name is Steve Immel. My business address is 526 South Church Street, Charlotte, North Carolina.
By whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas, and I'm the Vice President of Generation Transition Strategy.
And can you please briefly describe your role and responsibilities at Duke Energy?
My team and I are responsible for identifying and integrating the various work streams associated with the orderly and executable transition of the generation fleet.
Thank you. Turning to Mr. Nolan, would you please state your full name and business address for the record?
My name is Chris Nolan. My business address is 13225 Haggers Ferry Road, Huntersville, North Carolina, 28078.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas as the Vice President of New Nuclear Generation Strategy and Planning.
And can you please briefly describe your role and responsibilities at Duke Energy?
I'm responsible for the leadership and direction of the strategy and planning for new nuclear generation. This role is inclusive of policy, regulatory engagement, siting studies, and technology assessment.
Thank you. And last but not least, Mr. Pompey, would you please state your full name and business address for the record?
My name is Cliff Pompey. My business address is 526 South Church Street, Charlotte, North Carolina, 28202.
And by whom are you employed and in what capacity?
I'm employed by Duke Energy Carolinas LLC as the Managing Director of Generation Technology.
And can you please describe your role and responsibilities at Duke Energy?
Yes, I am responsible for providing leadership and direction for the review and awareness of new generation technologies, their domestic and global applications, functionality, performance, and potential application for Duke Energy. I also support the development of generation portfolios and technologies that ensure affordability for our customers, resource adequacy, energy sufficiency, and system reliability to achieve Duke Energy's carbon reduction goals.
Thank you. Mr. Repko, did the panel cause to be pre-filed in this docket direct testimony consisting of 57 pages and a summary?
Yes.
And do you have any changes to your direct testimony or exhibits at this time?
There was an error in my start date with Duke, but that was corrected in my rebuttal testimony.
And if I were subject to that correction, if I were to ask you the same questions today that appear in the panel's pre-filed direct testimony, would the answers be the same?
Yes.
And the testimony does not include any confidential information, correct?
Correct.
Chair Mitchell, I would ask that the long lead time resources panel direct testimony and summary be entered into the record as if given orally from the stand.
All right, hearing no objection, your motion's allowed.
Thank you. And the panel is now available for questions from the parties and the commission on the direct testimony.
All right, Avangrid, you're up.
Good morning. My name is Ben Smith. I represent Avangrid Renewables LLC in this docket. My client's interests in this docket are relatively limited to offshore wind development for the carbon plan, so my questions will mostly be focused there. That being said, some of these questions will be a little bit broader in scope, but relative to your direct testimony. I'd like to start with some background questions, and any one of the four of you, I think, could answer this. How many people does Duke Energy Progress have working full-time on offshore wind development at this time?
Your Honor, I would object. I'm not sure what the relevance of the number of people of one company working on offshore wind development is.
I think it's relevant to the extent that they're asking for near-term action plans to the long lead development, including offshore wind, to talk about where their status is right now.
All right, I'll overrule, I'll allow the question and do your best to answer it.
There is a team within our commercial affiliate working on that. I do not know the exact numbers. I also know that they are, engaging industry expertise with the development activities that are progressing after the acquisition of the lease area.
And the commercial affiliate, is that Duke Energy Renewables?
Duke Energy Renewables Wind.
Thank you. And so just to be clear, within the two Duke regulated utilities that presented the carbon plan, you're not aware of any offshore wind development personnel that are currently employed?
Not direct development personnel, the wind energy area lease, correct.
And taking that to the question of permitting, BOEM permitting, getting SAP, getting COPs, does the Duke regulated entities have personnel who are currently employed to do that permitting work?
That permitting work is being pursued for our commercial affiliate.
Okay, so Duke Energy Renewables,
Wind
Wind
LLC.
LLC. And how many projects has Duke successfully permitted in federal waters at this point?
We have not pursued permitting in any projects in federal waters at this point.
And talking to the four of you in this panel, do any of y'all have a background in offshore wind development?
None of the four of us on this panel do, but personnel within our commercial affiliate, Duke Energy Renewables Wind, does.
Thank you. All right, I'm going to move on to some questions about permitting and specific to parts of the direct testimony. And Mr. Pompey, I'm going to speak to you first, and probably mostly you. Moving to page 47 of your direct testimony. Just let me know when you're there.
I'm there.
Okay. You respond to the question, what are the near-term activities and costs associated with the development activities for offshore wind? And over the next few pages, You request approval to prepare a site assessment plan, or an SAP, and a construction and operations plan, or a COP, for an offshore wind resource, which you also request in the carbon plan. Can you confirm that the Bureau of Ocean Management, or BOEM, requires these actions of any offshore renewable energy leaseholder?
I can confirm that.
And apologies, I'm having a little bit of trouble hearing you. If you didn't mind speaking a little bit in
Yes,
the
if
mic.
you'd move the mic closer, Mr. Pompey.
Okay, is that better?
It's better. Thank
Okay.
you.
Yeah, I can confirm that.
Thank you. And is it your understanding in your work that non-regulated utility developers regularly execute this type of offshore wind permitting work?
I'm aware that, yeah, this work has been executed in the US, yes.
And so, since these permitting actions are required of any offshore renewable energy leaseholder, can you please explain why it is necessary for Duke Regulated to assume ownership of a lease area in order to perform those actions? Or I think you're saying, actually, I'm going to restate that question based on your earlier answer from Mr. Repko. Y'all are saying that your affiliate, Duke Energy Renewables Wind, will be taking the permitting work on.
They are progressing with that at the current time. I do not know at the rate at which that's progressing.
Sure. Part of the testimony sort of indicated that there were 4 steps that had to happen to sort of move through offshore wind. I think it was 4. And number 1, it was listed in order of number 1, there was a conveyance that had to happen. And then you would move forward with these different permitting activities. Is it fair to say that when you were describing those 4, you might not have meant them in that order, and it was just generally 4 things that had to happen? And I can find the reference point, but I'm just trying to short circuit a lot of these questions.
Chair Mitchell, I think it would be helpful if you
Sure.
could point the witnesses to the testimony.
Will do. Just give me 1 second. All right, I think I found it. Page 11 to page 12. And I believe this is Mr. Repko's testimony, but apologies if I'm off on that. Okay, reading from line 22, the primary near-term development activities for offshore wind are as follows. Number 1, secure an ownership interest in a lease for a wind energy area where the offshore wind resource will be located. Number 2, initiate and develop permitting activities, which will consist of A, developing and submitting an SAP and beginning to engage with stakeholders, B, developing a COP, and C, initiating an interconnection study process, and 3, obtaining a approval of an SAP from the Bureau of Ocean Energy Management. Is that a fair state? Did I recite your testimony accurately?
You did.
Okay, and so I guess what I'm asking is, it sounds like number 2 is occurring right now on your list prior to number 1.
Number 2, the development of around really the SAP is progressing at some rate within our commercial affiliate, the rate at which I'm not certain.
Okay. But is it Duke, and I'm talking about Duke Regulated, is it your position that you must secure an interest in a wind energy area prior to these permitting activities to be completed?
Yes. The acquisition for the companies to secure a wind energy area lease is essential to make sure that those development activities progress at the rate necessary to make offshore wind an option to the Commission for selection as part of the carbon plan.
All right, thank you. When you talk about to make sure that offshore wind is an option to the carbon plan, could you explain in what way would it, how could it progress where it wouldn't be an option?
It would progress at the point where the development and subsequent activities would make it viable in the time frame that the commission selects to meet the goals of House Bill 951.
Understood. So I'm going to move on and I might come back. I'd like to talk a little bit about the lease areas. And Mr. Pompey, this might be you, but it could be anyone. How many wind turbine positions could be located within the Duke Energy Renewables owned Carolina Long Bay lease area?
I'm sorry, can you clarify what you mean by wind turbine positions?
How many wind turbines? Excuse me, the large sort of fan-looking things that's been produced.
Yeah, so that number is variable and it's based on technology development. So you have to look at what's available today and what's going to be available in the coming years. So, you know, it could be anywhere from something in the 60s to something in the 90s, and you have to do the work to determine your wind profile such that you can determine how best to maximize the wind energy area.
Thank you. And can you talk a little bit more about what work has been done by Duke Regulated to get that profile?
The Duke Regulated group, we looked at high-level potential layouts for the area prior to the lease execution, but the work to get to any actionable level has to happen from here going forward, and that's really what we're asking for, to, as you know, Mr. Repko mentioned, to maintain the timeline for availability of wind to be selected if the commission selects offshore wind.
It is a key point that we have verified that the lease area of Carolina Long Bay that was acquired by our commercial affiliate can meet all of the needs in terms of the capacity, the generation that has been modeled thus far in the carbon plan.
Thank you. And how many of those, you spoke about 60 to 90 and spoke about doing some of the development. How many of the wind turbine positions in the Duke Energy Renewables wind-owned Carolina Long Bay lease area are at risk of being lost due to the 24 nautical mile viewshed buffer that's currently being requested by various North Carolina delegates?
Yeah, that's an interesting question because the number is not so much dependent on the 24 nautical miles. It's really dependent on the stakeholder work that has to happen to really determine what the best positioning is from a viewshed perspective. The 24 nautical mile number is based off of a static understanding of what was presented in other projects, and it's really more dynamic than that. There's work that has to be done to determine what the viewshed is, and that's when you would look at how many wind turbines would be put out there, as well as how to best meet the output requirements.
So is it fair to characterize your testimony as that Duke is seeking to have a static 24 nautical mile viewshed buffer changed to reflect a more dynamic model that you see for your project?
No, that is not fair. I think what I was alluding to is that Duke Energy would continue to do the work as we have always done to work with our stakeholders to ensure that we meet their needs and that 24 nautical miles is just a number. The real work has to be to ensure that the communities that we serve are heard and that we meet their needs and their concerns.
And what stakeholder activities are currently ongoing related to the 24 nautical mile viewshed buffer?
I'm not aware of the specifics that are currently occurring with the Duke Energy Renewables wind.
Again, there's a couple key aspects to keep in mind. So opposition relative to offshore wind projects is common. The Vineyard Wind Project by Avangrid Renewables had opposition as well. And again, through stakeholder work process, you work to reconcile that through a number of different ways. The second point is that BOEM in the initial input before the auction of the Carolina Long Bay recognized the stakeholder input around the viewshed concerns and extended that out to 18 nautical miles.
Right, they did go 20 miles.
And then the third point I would bring out that's relevant around the Carolina and Long Bay lease is that it's a triangle shape. And our commercial affiliate sought that lease very purposefully, that any extension of exclusion area to account for viewshed would result in a minimal loss or a lower loss of the number of turbines.
Well, let's talk about that point then.
All right, Mr. Smith, let's break. Let's stop now. We're going to take our morning break. Let's go off the record. We'll come back in at 11:15.
Thank you. I'm actually going to go back. I was able to review my notes. I'd like to go back to permitting for just a minute and then go back to the viewshed buffer. Are y'all familiar with the BOEM requirements for SAP and COP permitting?
Yes, those are prescribed in the Code of Federal Regulations.
And within those requirements, regardless of a conveyance from to Duke regulated, Duke Energy Renewables Wind is required to complete an SAP and a COP within certain timeframes, or the way I say risk forfeiture of the lease, correct?
There are timeframes prescribed under the BOEM process and or the Code of Federal Regulations. BOEM does have discretion to extend those timeframes, and they have done that for projects.
Okay. And those timeframes, is it your understanding that it's SAP must be submitted within a year of the lease acquisition and a COP must be done within 5 years of the SAP? Is that your understanding?
That is correct. And again, BOEM does have discretion and has granted extensions to those timeframes.
Okay, I'm going to move on back to the viewshed risk. All right, so before we took our break, you had mentioned that the Carolina Long Bay lease area is triangular shaped, and I'm not going to restate what you testified to, but I'm going to ask sort of about if the 24-mile static nautical, 24 nautical mile static viewshed buffer is sort of held up and sort of required for the Carolina Long Bay lease area, Duke Energy Renewable Wind, Carolina Long Bay lease area. Do you know, did you say if you know how many turbines would be lost?
So it did not say. So a couple key points. So the 24 nautical mile exclusion area is not required, not enforceable because it's out in international waters beyond the 3-mile timeframe for state jurisdiction. However, it will be our intention to develop any offshore wind project commensurate to the communities that we serve and through a stakeholder process.
So just so I have this clear, if you are following through with the static 24 nautical mile viewshed buffer, do you know how that would affect the Duke Energy Renewable Winds Carolina Long Bay lease area and the amount of turbines it might have?
I do not.
I'm not aware of a particular number, but I will say, and to reiterate or to back up what Mr. Repko mentioned, and beyond that, he did mention the shape, right? Any loss of area is minimized because of the shape of the wind energy area, as well as, these things are dynamic and there are various ways that you can set up the wind turbines, different wind turbine sizes to optimize the energy that you get out of the wind energy area. So, we seem to be stuck on the nautical mile buffer, but I don't think that's the full story of how you optimize a wind energy area.
I agree. Are you aware of any current North Carolina delegate protests to the Kitty Hawk lease area?
I am not.
And is it your understanding that the Kitty Hawk wind lease area falls outside of the 24 nautical mile viewshed buffer?
It is.
Okay. So let's say half of the turbine positions were lost to viewshed risk, and the maximum project capacity in the zone was less than even one right-size HVDC project. Would you still consider that to be a prudent investment on behalf of ratepayers?
Objection, Chair Mitchell. This hypothetical assumes many different facts that really have no bearing on there's nothing in the record that would yield that these are reasonable facts for a hypothetical.
I can move on.
Okay.
I want to go to page 42 of your direct testimony. there's a statement that says the relatively high capacity factors and lower intermittency for offshore wind. And I'll cut it off there because that's where these questions go to. Can you explain the relevance of net capacity factor when assessing a generation asset, and in particular an offshore wind asset?
Sure. So in my statement where I say relatively high capacity factor and lower intermittency, I go on to talk a little bit more about how offshore wind really complements solar. And in the carbon plan, there's a high level of solar that is being proposed, and offshore wind very well complements that. On the capacity factor side, the higher the capacity factor, the more energy you can get out of a wind energy area.
And do you know the relative net capacity factors profiled for the Duke Energy Renewable Winds Carolina Long Beach area and the Kitty Hawk lease areas?
I do not, and I'll elaborate on why I don't. Specifically, the work that we're proposing to be done as part of the SAP involves meteorological work and assessment work that would further refine the Carolina Long Bay wind energy area that would give us the information to be able to say definitively what the net capacity factors are. Any numbers that are out there currently on net capacity factor are based off of available wind data that is outside of the wind energy area. So they're subject to refinement, and that's really what we're asking for.
I want to clarify. I think, and correct me if I'm wrong, did you just say that any numbers that are out there are outside the wind energy areas?
There, to my knowledge to date, there have not been any meteorological wind studies that have been done inside the wind energy area. Any potential net capacity factors are based off of wind data from towers that are outside of the Carolina Long Bay wind energy area.
Okay. And getting back to NCF a little bit, NCF net capacity factor. Sorry, I know we death by acronym. Would you agree the most important input to determining an offshore wind facility's NCF is its wind speed?
No, I would disagree. I think wind speed is one aspect of net capacity factor. Another important aspect is the layout of the site, how you choose to put wind turbines. And another one is when you get into engineering, you select a wind turbine that is optimized for the particular wind speed.
Thank you. And I think you've answered this question, but so apologies and any objection, but have you had a meteorologist provide a report on the wind speeds and NCFs of the Carolina Long Bay or the Kitty Hawk lease areas?
No, we have not. And again, I'll reiterate, I think that, the long lead work that we're asking for approval to undertake is specifically so we can get to that level of detail and be able to, ascertain what those net capacity factors would be.
Thank you. And have you looked at the publicly available data resources such as NREL or energy.gov at the wind speed in the Duke Energy Renewable Winds Carolina Long Bay lease area and in the Kitty Hawk lease area?
Yes, we have.
And how do they compare?
The Kitty Hawk parcel has a higher wind than the Carolina Long Bay, and so would expect a bit of a higher capacity factor.
So it's fair to say that publicly available third-party data suggests that the Carolina Long Bay lease area has a material lower wind speed than the Kitty Hawk lease area, and so Kitty Hawk is very likely to have a materially better NCF?
Objection that the question is vague. Material is not defined.
I will restate without the word materially. Is it fair to say that as
Mr. Smith, let me rule on the objection. I'm going to sustain the objection, restate it, and also do your best to avoid a compound question.
Is it fair to say that based on publicly available third-party data, that the Carolina Long Bay lease areas have materially lower wind speeds than the Kitty Hawk lease areas?
Renew my objection, Chair Mitchell.
All right, and I'll sustain it. Mr. Smith, ask it in a different way if you can.
Sure, I restated something that I shouldn't have. Mr. Pompey, is it fair to say the Carolina Long Bay lease area has profiled in publicly available third-party studies lower wind speeds than the Kitty Hawk lease area?
It is fair to say that. That is available data. And I believe, we're talking about the net capacity factor. And I'll just remind you, Mr. Smith, that, there's more than just a particular wind speed that goes into the net capacity factor, although it is an important piece. The actual number, right, the actual net capacity factor is not knowable at this point because the work hasn't been done.
But based on publicly available third-party data, Kitty Hawk is likely to have a better NCF than Carolina Long Bay lease area?
That is correct. And I think the quantifiable number is unknowable. How much better?
Has Duke Regulated done any, actually scratch that. I'm going to move on. Has Duke made their own estimation of equivalent CapEx value to reflect materially different net capacity factors between lease areas?
Yes, I believe we looked at that.
And can you tell me what the conclusions are with regard to CapEx comparisons between Kitty Hawk and Carolina Long Bay?
Without getting into the specific numbers that I don't have on top of my head, I think what we established was, as I mentioned, there are very many factors that go into one of these projects. We felt that on a CapEx perspective, the lower net capacity factors were offset by the shorter transmission distances from a CapEx perspective, Carolina Long Bay to Kitty Hawk.
And to your point about the important factors in considering net capacity factor, including design, it's fair to say that all developers could design their lease areas in the optimal manner, correct?
Absolutely.
I'm going to move on to page 49 of your direct testimony. Are you there?
Yes.
There's a table of cost estimates at the bottom of page 49. Do you see that?
I do.
Referring to the table, how did Duke estimate the $62 million figure for development expenses?
So we looked at what type of work would be required in the next couple of years, and we gave it a high-level estimate as to what would be required to be done in the next couple of years to get the development of the Carolina Long Bay lease area to a point where we felt like we could come back to the commission with better, more refined information.
So would you expect a similar projection of development costs to apply to either of the other two lease areas?
So this is just based off of our estimate. I wouldn't venture to say what other entities are spending to develop their lease areas.
Sure. But it's Duke's position that this development cost is specific to Duke Energy Renewable Wind's Carolina Long Bay lease area?
No, these are our estimates on the regulated. We don't know what Duke Energy Renewables Wind has allocated or what their estimates are to perform this work.
I'm sorry, I might have misstated the question. I guess I'm asking, is this $62 million figure specific to the Duke Energy Wind, Renewable Wind, Carolina Long Beach lease area?
Yes, specifically, we're talking about the work to get the lease to get the wind energy area from lease to SAP.
Okay, thank you. All else being equal, well, actually scratch that. In terms of making decisions about near-term development for long lead, would you agree that a lease area with similar development, capital and operational costs, but with a better wind speed would deliver more value to ratepayers?
I would disagree. As I just mentioned a few minutes ago, there are lots of factors that determine what the value is going to be. I think there's obviously total CapEx is part of that. And if you look at the two lease areas, there are significant differences that would go into the CapEx. And I think we would, again, say that the net capacity factor is offset by the longer transmission line going from the facility to the point of interconnection.
Okay, thank you.
I would also add that the criteria for House Bill 951 is not the lowest cost per any single resource. It's the lowest cost path. So you can actually have just the necessary component of offshore wind to meet the desired decarbonization goal and time frame. It might be slightly higher in cost, but still contribute to have an overall lower cost path than a fully larger developed project.
Thank you, Mr. Repko. I'm going to move on to page 47 of your testimony. If you could turn there, please. On page 47, you say, assuming the commission agreed that it is prudent and reasonable to pursue further offshore wind development activities, the companies would seek affiliate approval from the commission to transfer the Carolina Long Bay lease area from Duke Energy Renewables Winds LLC. I was hoping you could take me through what does that conveyance look like from a regulatory perspective?
So I'm going to go ahead and defer this question to Mr. Repko, who I think is better equipped to answer.
It would be
I'll just note, Chair Mitchell, that this may get into also legal response in terms of what an actual affiliate transfer application looks like. So to the extent Mr. Repko can answer it, he will, but there's also a legal component to it.
I'm only asking about regulatory actions that Duke regulated would need to make.
Proceed with the question.
Would you like me to restate?
Please.
On page 47, it says, assuming the commission agreed that it is prudent and reasonable to pursue further offshore wind development activities, the companies would seek affiliate approval from the commission to transfer the Carolina Long Bay lease from Duke Energy Renewables Wind LLC. Can you take me through what regulatory activities Duke regulated would have to do for that conveyance?
Yes. As I understand, it's an affiliate transfer. Right, so it is a legal transaction between the two, between our commercial affiliate and the companies, or the company, DEP. And then it would be a subsequent acceptance of that affiliate transfer by the commission.
And what other, actually scratch that. Would there be any other requirements from a regulatory perspective beyond the affiliate transaction review by the commission for Duke to move forward with the Duke Energy Renewable Winds Carolina Long Bay lease area wind development?
I believe that transfer would also have to be filed and recognized by BOEM.
But is there any sort of further certification that would have to be done at the North Carolina Utilities Commission, like a CPCN filing, CEPCN?
Not that I'm aware of for the affiliate transfer.
Actually, I was talking about the development of Carolina Long Bay. What would have to be done for moving forward that development?
So what we're asking for in this proceeding is a decision to incur the costs associated with the development of the three long lead items, offshore wind being one of them. So we're really looking for decision direction by the commission that they want offshore wind to be considered as an option and developed to that extent to make it available as an option. And we have those We provided a view of what those development activities look like and an approximate cost for that. So in terms of the actual costs incurred and recovery of that, we would be looking for a separate proceeding, whether that be another carbon plan or rate case or anything of that nature, that we would be required to demonstrate the reasonableness and prudency of those costs associated with the development of those resources.
Okay, thank you. I'm going to move on to timing. Are you familiar with HB 951's requirement the commission take all reasonable steps to reach a 70% carbon reduction goal by 2030?
Yes.
In your testimony at the bottom of page 43, you referenced the Dominion CVAL project. Let me know when you're there.
There.
The CVAL project was inquired in 2013 and hopeful to achieve a 2026 COD, which is a 13-year development timeline. Is that correct?
Correct.
And in your testimony on that same page, you reference an 8 to 10-year minimum timeline to achieve COD from lease acquisition. Isn't that right?
That is correct.
Is it your understanding that the Kitty Hawk lease area was purchased at lease auction in 2017?
Yes, so this was my testimony. I am familiar with that.
Okay. And Mr. Pompey, is it your understanding that Kitty Hawk has been developed ever since, including achieving both SAP and COP submissions, as well as significant engineering studies? Same studies which you call out on page 55 of your testimony as important de-risking agents?
It is my understanding that Avangrid Renewables has submitted a SAP that was accepted and has also submitted a construction and operations plan, a COP, that has not yet been approved.
And the Carolina Long Bay lease area was only purchased this past May and has had significantly less time than Avangrid Renewables has had to do the permitting work that you just referenced.
Objection, using the word significant, again, it's vague, it's not defined.
Would you agree that?
Let me, that's okay. Let me, do you have a response to the objection that you'd like me to hear?
I can restate the question differently.
All right, also sustain the objection and please restate the question.
Would you agree that Duke Energy Renewables Wind has had less time to do their SAP and COP permitting work than Avangrid Renewables has had for Kitty Hawk?
Yes, I would agree to that. And I would also state that, the timeline as laid out in my testimony still stands at 8 to 10 years.
And moving to page 50 of your testimony. You make a statement that, are you there?
Yes, can you also refer me to the line because it's hard for me to follow?
Lines 19 to 20.
Yes.
You state that to try and, or am I characterizing your testimony correctly to say that to try and construct a project out of the Duke Energy Renewable Wind Lease ready area to be ready to deliver power by 2030 could present significant financial risk for the companies and its customers?
Yes, that is what I stated. And, in my testimony, I stated that, the earliest timeframe that we would expect Carolina Long Bay to have commercial operations is by year end 2030, based on the 8 to 10 year development cycle. There are significant risks with that in terms of procurements prior to getting final BOEM COP approvals. So, yes, that is.
So given all of what you've just said and the 2030 deadline we just discussed, how do you respond to the concern that the Duke Energy Renewables Wind Lease area is not the best suited option to achieve HB 951's required timeline?
I think there.
I would object. The 2030 is not the characterization that it's a deadline. An interim target in the statute.
All right, Mr. Smith.
We've taken the position that the 2030 is a deadline. So I guess I would ask, I guess I could, submit that it's a legal argument, but I wouldn't mind restating the question within the guidelines that.
All right, so I'll sustain the objection, restate your question.
So restating, apologies if this gets a little marble-mouthed. How do you respond to the concern that the Duke Energy Renewable Winds lease area is not the best suited option to achieve the 2030 70% reduction?
If I may, I will answer that. We acknowledge in the carbon plan, Appendix J for wind, that if the 2030 date is the date that the commission chooses, that a parcel that is further along in development would be the most likely course of action. That is the Kitty Hawk parcel. However, beyond that, any extension beyond that, 2032 or beyond, allows for options, including Carolina Long Bay, that can be developed in both time frame and scale at the commissioner's choosing by the companies.
Thank you. Okay, moving to some cost effectiveness questions. Would you agree that compared to solar and other fuel resources, and this could be for either Mr. Repko or Mr. Pompey, offshore wind is a time and capital intensive asset class?
Yes.
Has Duke commissioned any third-party studies to ensure that your near-term action to acquire Carolina Long Bay from Duke Energy Renewables Wind is the most cost-effective solution for ratepayers?
Again, I'll go back to our modeling in terms of the amount of offshore wind within our models. So we have very deliberate portions of offshore wind, including throughout our modeling portfolios that contribute, and we've shown the cost of each in terms of how that contributes. Again, I'll make the point that the criteria of House Bill 951 is not the lowest cost of a wind project or a solar. It is the least cost path, the cost of the overall portfolio to achieve the carbon reduction goals.
Yeah, I don't think anyone would disagree with that. So if you haven't done any further studies beyond modeling, and correct me if you have, can you explain to me why acquiring a lease made later in time for an offshore wind lease area without permitting it and potentially worse project fundamentals is a good deal for North Carolina ratepayers?
Objection, it's a compound question, as multiple facts that are not in evidence.
Well, I disagree. We've established that the offshore wind lease area was acquired later in time. The permitting has not been completed. And we've talked about project fundamentals. We can have a disagreement about whether good or bad on wind factor and whether to rely on NREL and energy.gov wind speed characterizations. But I do think that it relied upon facts that are before the commission.
And the Kitty Hawk permitting is not completed either.
Kitty Hawk's witnesses will have the opportunity to testify as to the status of the Kitty Hawk wind lease area's permitting.
All right, let's do this. I'm going to overrule the objection, but I'm going to direct you to break your question up so that you don't have compound question. State it clearly so the witness understands what you're asking and he can answer, and we'll give his response the way it's due.
Can we agree that the Carolina Long Bay lease area was acquired in a BOEM auction later in time than the Kitty Hawk?
Yes.
And can we agree that the Carolina Long Bay wind lease area permitting, as far as you know, has not been completed?
Yes, I can agree to that.
And can we agree that wind speed factors contained and published by NREL and energy.gov show higher wind speeds for the Kitty Hawk wind lease area than the Carolina Long Bay lease areas?
Yes, and I will add again, because I believe I addressed this earlier, that the wind speed is only a factor. And specifically, there's one other factor that negates the wind speed differences between the two areas.
And what is that other factor?
It's the capital cost of the longer export cable from the offshore wind farm to the point of interconnection.
And can you characterize the difference in cost between the two?
I can. So in Avangrid's direct testimony, they actually had a arithmetic error. The characterization was each percent of net capacity factor represented $50 million in CapEx, which I'm not disputing. I think that's close to our numbers. The testimony stated that the Kitty Hawk net capacity factor was 43% versus Carolina Long Bay's 36%. As I stated earlier, that's not something that's knowable right now because the work hasn't been done for the 36%. But even if we accept that, that represents a 7% difference in net capacity factor at $50 million per percent of net capacity factor. And that's directly in Avangrid's testimony. They stated that the difference in CapEx is $850 million. The arithmetic doesn't work. It's $350 million. The export cable from Kitty Hawk to the point of interconnection, which you've heard from Witness Roberts, is New Bern, as at least the way we see it in terms of least cost path, has the Kitty Hawk export cable at roughly twice the length of Carolina Long Bay. You would have to use a high voltage DC, which works out to roughly $340-ish million of additional CapEx for the double length high voltage DC export cable.
So without conceding any of Kitty Hawk's points they made in their testimony, am I understanding you to say that there's still a delta between the costs associated between the potential value of the Kitty Hawk lease area versus the costs of what you claim is the longer interconnection cost process?
No, I don't see a cost delta. What I see is high-level estimates that are roughly within, error margins of error around $350 million in terms of offset.
So 350 million, 340 million, give or take a few million bucks.
So I think that, at this point, we are not looking at, estimates that are project specific. We're looking at high-level estimates. 350 million could easily be 328. 338 could easily be 360, right? We don't have any indicative pricing. We haven't done, procurements to know exactly. These are just estimates based off of GIS data of what the cable lengths could be and based off of public information of what these high voltage DC cables run on a per mile basis.
And it's your understanding that, or is it your understanding that Avangrid Renewables contests Duke's position on the amount of cabling that needs to be done?
Yes, it is. And that was really the point of my statement here is that without getting into too much detail, there are lots of concerns with the proposed path that Avangrid is suggesting to get to their lower export cable length, specifically going through the Pamlico Sound and the Neuse River. We think there are significant environmental concerns associated with that proposed path.
So would it be fair to say that a third-party transparent study of the three different wind lease areas might lead us to a conclusion about these different things?
I don't think that's necessary because the process itself for getting the permitting is very clear in terms of if you're going to disturb environmentally somewhere like the Pamlico Sound that has relies a lot on fishing, there's wildlife, that you should be seeking alternatives. And only if there are no alternatives would you do that. I don't think we need a third-party study to tell us that the alternative is to go through the Atlantic Ocean.
Okay, so given the high stakes involved for ratepayers on embarking on an offshore wind project, which you've done a very good job of sort of outlining some of the risks involved here, and the fact that there are at least two options available to North Carolina ratepayers in terms of Kitty Hawk and Carolina Long Bay, Do you agree that it's imperative to choose the better of the two options to serve ratepayers in accordance with House Bill 951?
I'll answer that. There has not been an explicit statement by Avangrid that they are willing to sell the Kitty Hawk parcel. They have made expressions of interest, but they have not clearly stated that they are willing to sell. We don't know if they would sell. We don't know at what price. We don't know at what time frame, nor can they be compelled to sell. So if we go back to September timeframe of last year, BOEM began communications that they intended to auction the Carolina Long Bay. It was called Wilmington East then, but I'll stay with the Carolina Long Bay parcel. So at that time, we were aware of that. In December comes legislation of House Bill 951. And with that auction, the reason BOEM was auctioning the Carolina Long Bay early in this year, 2022, is because there was a federal moratorium on offshore energy exploration that took effect July 1st of this year. And what that means, or what that meant at that time, there would be no opportunity for further offshore wind parcels for up to 10 years. That is the length of the moratorium. So with that lens, that we have House Bill 951, offshore wind could potentially be a component of that and not have the option in the lease coming around Carolina Long Bay. The senior management of the company directed that all options for a wind energy area be assessed and pursued. The outcome of that evaluation, assessment, and pursuit is that we participated, or there was direction that our commercial affiliate participate in the auction for the Carolina Long Bay. The commercial affiliate, Duke Energy Renewables Wind, won the parcel. So there is a parcel immediately available to the companies. It is available at cost. That cost was demonstrated to be at market for a lower price of the two in the auction that was conducted by a third party. So it is the clearest and most straightforward path for offshore wind, for the company to develop offshore wind to a scale and time frame at the discretion of the commission.
Thank you, Mr. Repko. At the beginning of that answer, you referenced that Avangrid Renewables has not taken a position that they would like to sell Kitty Hawk wind lease area. Is that right?
That is correct. They have not made an explicit statement in their testimony that they would sell.
Do you have the Avangrid Renewables direct testimony in front of you right now?
I do not.
Chair, I didn't anticipate that he would reference the Avangrid Renewables direct testimony, so I don't have copies for the witness. Can I ask questions on it subject to check?
Can you show him one copy?
Do you have a copy of the testimony or
Yep.
that you can put in front of him? And
Mr. Snowden's going to help me out.
let's let his counsel look at it as well.
Thank you, Ben. You don't have it. Thank you. Yeah, I should have printed it out. First.
Thank you.
Thank you. Thank you.
Okay. I've just handed you the direct testimony of Michael Sterrett and Becky Gallagher. Is that correct?
That's correct.
And this testimony was made on behalf of Avangrid Renewables LLC. Is that correct? You can see the top of the page.
That's correct.
Okay, I'm going to begin reading at line 3. Ms. Gallagher, please comment on the future prospects for the Kitty Hawk lease area and whether Avangrid Renewables would consider selling the Kitty Hawk lease area. Answer. Avangrid Renewables is open to any manner of transaction that is on reasonable terms and fairly values the Kitty Hawk lease area, including PPA transactions or a sale of the lease area in whole or in part. Do you see that testimony?
I do.
Can you explain the delta between what this testimony says and your position that Avangrid Renewables says that it is not explicitly for sale?
Yes, it says it's open to manners of transaction. It talks about reasonable terms, fairly values. So there is nothing, I mean, all those are subjective subject to negotiations. So there is no certainty that it would sell. It also includes transactions such as PPAs that are not within the realm of House Bill 951 prescriptions of ownership.
We can discuss the prescription of ownership for, I believe you said it was cited in international waters, offshore wind at a different time, but I want to focus on sort of what you're saying with regard to open any manner of transaction that is on reasonable terms. Is it your position that Avangrid Renewables shouldn't be allowed to negotiate for the sale of the lease area?
So our position is that, again, with the backdrop of what transpired around the timeline of House Bill 951, we pursued all options for a wind energy area lease. And when no other options were available to us, we decided to participate in the BOEM auction for the Carolina Long Bay wind energy area to ensure that offshore wind was available for the commission's discretion for the carbon plan.
Okay. So just to get back to your earlier point about Kitty Hawk not explicitly being for sale, would you agree that it would be explicitly for sale following a negotiation between two parties based on this testimony?
I can't say where those discussions would end.
I'm going to move on. All right. Going back, and this is goes to the request that's made in the carbon plan about near-term actions to sort of enable offshore wind. Has Duke commissioned any third parties to ensure that their near-term action plan to acquire Carolina Long Bay from Duke Energy Renewables Wind is the most cost-effective solution for ratepayers?
Objection. I think that's been asked and answered. I think he asked that about 15 minutes ago.
All right, I'll move on then. I don't recall asking that, but I'll take your word for it. For the carbon plan, are there any generation or ancillary service sort of projects that are actually, let me strike that and start that question over a little bit more clearly. Are there any generation assets in Duke's carbon plan that are going to be subject to a RFP process?
Yes.
Can you tell me about those?
I mean, generally, there's the exception carve out relative to solar, but even within the realm of the ownership aspects of the utilities, we go through RFP, competitive bid events for EPC services and things of that nature. And we would do that with any development of an offshore wind project as well. So resources, expertise, we would seek that out, go through competitive bid, particularly for construction and development activities. So really broadly across the whole generation portfolio replacement, there would be competitive bidding such as RFPs associated with it.
And What about a type of build own transfer structure or anything like that? Is there anything like that that's going to happen commensurate with the carbon plan request for the Duke?
Build own transfers are an option. As a matter of fact, we have had outreach by European developers of offshore wind that were interested in a build own transfer model relative to the Carolina Long Bay parcel.
And is that something that you would be open to doing to any of the offshore wind lease areas off the coast of North Carolina?
Again, it's our desire that it's appropriate from an ease and simplicity and a time frame standpoint that we develop the Carolina Long Bay parcel.
So you're bypassing a more competitive structure?
No, I'm reflecting on the history of what transpired in terms of us pursuing and evaluating lease options.
Would Duke be interested in a joint ownership venture on any of the offshore wind lease areas? A 51-49 split or something else creative?
Our position is House Bill 951 precludes that type of arrangement.
So Duke regulated has to be the sole owner of any project, including any offshore wind sited in international waters.
That is our understanding of House Bill 951.
Okay. That's all I have.
All right, CCBA.
Thank you, Madam Chair. Gentlemen, my name is John Burns. I'm the General Counsel of Carolina's Clean Energy Business Association, which I'll refer to as CCBA, and you'll hear that a lot around here. So it's a pleasure to talk to all four of you today. Most of my questions will be directed to Mr. Nolan because they're directed at SMRs and new nuclear. That's the topic I intend to cover today. To the extent any of you other gentlemen have any input, please interject, but let's only talk one at a time for the benefit of the court reporter. So I'll go with that. Duke anticipates that new nuclear will be an indispensable part of any of its proposed portfolios, doesn't it, Mr. Nolan?
That is correct.
There's no portfolio in Duke's carbon plan that gets to net zero by 2050 without the deployment of new nuclear technology.
That is correct.
You go into the differences in your direct testimony, but SMR and advanced reactors are not the same thing in Duke's lexicon. Is that right? You're referring to two different things?
That is correct.
Can you briefly distinguish between those two?
And Mr. Nolan, could you move closer to the mic a bit?
Thank you.
Thank you.
I should have said that myself. Go ahead.
Thank you. So small modular reactor typically refers to size that's 300 to 350 megawatts or less. In the context of clarity and the testimony, when we talk about SMRs, we're talking about light water reactors.
Okay.
Advanced reactors can also be SMRs, but we chose to talk about them as advanced reactors, meaning they're not light water cooled.
Is that a consistent terminology across the industry, or might there be references in the in documentation that refer to SMRs and they're actually referring to things like molten salt reactors that you refer to as advanced reactors?
There could be, so there's lots of different titles. There's advanced nuclear, advanced reactors, advanced small modular reactors.
Okay.
What we try to do is provide clarity and use SMR for light water and advanced reactor for not light water.
Thank you. I have a few questions about SMRs first, if you don't mind.
Certainly.
How many SMR reactors are included in one plant as modeled for the carbon plan?
So could you clarify your question?
My understanding is that one of the benefits of SMRs is that multiple reactors can be placed at one location, inside one building, for instance, that might have more than one reactor in that plant. Is that right?
So different designs have different attributes. I appreciate the clarification. So if you're talking about a new scale reactor, all the modules are in the same pool.
Okay.
And so they can be either 50 or 77 megawatts. There can be 4, 6, or 12.
Go ahead, sorry.
If you look at the GE BWRX 300, it is a unit that's 285 megawatt electric in a building, and you could put multiple buildings on a site.
And so because Duke has not identified a particular technology or a particular manufacturer that it wishes to adopt as part of its future plans in North Carolina, you can't tell us whether it'll be one 275 watt small modular reactor or, multiple 75 watt small modular reactors in the anticipated units to be brought online in your plan.
We have not selected a technology.
Okay, thank you. According to figure 6 of the executive summary of the carbon plan, that's on page 14 of the carbon plan. I don't know if you have that with you. I think because it's been referred to so many times, I think we can refer to it and subject to check, but there will be, new nuclear will not be part of any of the 4 portfolios proposed by Duke before 2030. Is that correct?
Or what date?
2030.
I think that's a true statement. I don't know if that's in the carbon plan.
Gotcha. Portfolio 3 and Portfolio 4 both bring on 0.3 gigawatts or 300 megawatts of new nuclear online by 2034. Is that consistent with your recollection?
That they would be online by 2034, correct?
All right. And about 300 megawatts would be one plant.
It could be, yes.
Okay. By 2035, is it correct that all 4 portfolios proposed by Duke would have approximately 600 megawatts of new nuclear?
That is correct.
And that's can be found in figure 7 for reference for the testimony and for the transcript. And so based on the math you just did, 600 megawatts would probably be 2 plants. All right. To be clear, however, at least one of Duke's proposed portfolios would in fact reach 70% reduction by 2030 in CO2 levels, according to Duke's own modeling. Isn't that right?
That is correct.
And it would do that without any new nuclear plants online of any design.
That is correct.
As I understand your testimony and the materials presented in the carbon plan, Duke believes that SMRs are the best option for initial investment in new nuclear. Is that right?
That is correct.
Meaning the the water reactors that you referenced earlier.
I think what we are saying is light water reactors are more similar to the reactors that we operate today.
Okay. And the SMRs, oh, sorry, please continue.
And therefore, there is lower technical uncertainty associated with their development and deployment.
Okay.
And so for an aggressive schedule and aggressive deployment, we're recommending light water reactors.
And in layman's terms, it's because the technology is similar to what might be down at the Harris plant, but newer and smaller.
Correct.
Okay. But you have not yet chosen a design or a manufacturer.
That is correct.
Okay. Is it fair to say that Duke believes that SMR technology will lead to a supply chain for small modular reactors?
I believe if you look at the actions of the administration and the funding that DOE is providing and the tax credits that are in the Inflation Reduction Act, the government is moving in that direction. I think utilities are watching that. So I believe we're seeing a general movement in that direction.
And we've heard this, I think, a few times in the last week and a half, that the IRA will have an effect going forward on the technology being discussed. Would that apply also to nuclear?
There are components that apply to both nuclear in terms of production tax credit, investment tax credit, and if a unit integrated storage, it could potentially qualify for a storage credit as well.
Would you agree with me that we may not know the full implications of the IRA before 2034? Or let's see, let me rephrase that. We may not know the full implications of the IRA on nuclear technology before the end of 2033? 2023, I can't talk.
I think we are looking to see the guidance that will come out from the Department of Treasury on how to apply those credits to see their value and then roll them into what our cost estimates would be.
Is one of the advantages that if we move towards this technology, as you discussed in the administration's course of action, that it may lead to construction of these types of small modular reactors off-site and delivery to your site? Is that how it would work?
The idea with a small modular reactor is their standardized design, modular, which means it's more off-site construction. There will be some field construction, but less.
But there's no such supply chain as of yet, is there?
One has not been built. That is correct.
And there's no factory constructing modular parts for modular reactors in the United States, is there?
I can't make that sweeping statement.
There's no current SMR anywhere in the world that is generating power and providing it for commercial operation, is there?
That is correct.
Certainly not one in the United States.
That is correct.
And that includes both liquid-cooled small modular reactors and the advanced reactor technology that you also speak of in your testimony.
That is correct. But I would qualify that statement by talking about the advanced demonstration projects that are currently being funded by the Department of Energy that will put a small modular reactor, an advanced reactor in Wyoming and an advanced reactor in Washington State before the end of the decade.
Is it a fair comparison to compare that to sort of the prototype of a new car model that out there, it works, it drives down the road, but they're not manufacturing 10,000 of those this year?
I think it's a very important step. I think it will answer a lot of questions and something that the rest of the industry can learn from.
Okay. In addition to not having chosen a technology yet, Duke has not identified a site selected for the construction of an SMR plant, has it?
That is correct.
In fact, your recommended near-term execution plan seeks authorization to engage in the permitting and site selection process.
That is correct.
According to, I don't know, you don't have the carbon plan in front of you, but I understand from table 4-1 on chapter 4 of the carbon plan that Duke seeks permission to, quote, begin new nuclear early site permit for one site as part of the near-term execution plan. Do you have that in front of you?
I do, yes.
Okay, that's a table 4-1, and in the lower half of that table on page 5 of chapter 4, it discusses the proposed resource development options for the 70% interim target. And under new nuclear, to the right, it says begin new nuclear early site permit ESP for one site.
Correct.
So you anticipate an ESP process for one site by 2030.
That is correct.
Can you tell me what is included in, well, actually, the second bullet point under that is to begin development activities for the first of 2 SMR units. Is that right?
Correct.
Can you tell me what is included in beginning development activities for the first of 2 SMR units?
Certainly. So for an early site permit that is technology neutral, you develop a plant parameter envelope which bounds the technologies of interest, and then you evaluate how many units could fit on that site based on the attributes. And you look at both the environmental and the site safety characteristics of the site. It's a very important step in terms of regulatory risk reduction. It addresses environmental issues under NEPA, the National Environmental Protection Act, and also addresses site safety issues like flooding, upstream dam failure, and looks at the seismic suitability. In doing the seismic suitability, you need to have some information about the technologies.
Right.
And so really the development activities would be to understand the technologies, assess the technologies, and then gain the next necessary technical information to support the licensing process.
Does that process include notifying local governments that Duke proposes to place a nuclear plant in their community?
So the NEPA process associated with the early site permit has extensive community engagement.
I understand that the Nuclear Regulatory Commission has amended the emergency zone that might apply to a small modular reactor as opposed to a current technology nuclear plant. Is that correct?
It's technology specific, but yes, the NRC is looking at the characteristics of the reactor and evaluating the emergency planning zone accordingly. If you look at some of the advanced reactors, if you look at the nature, it operates at atmospheric pressure. So there's no real energy to drive a release. If you look at the X energy, the containment structure is the fuel pebble itself. If you look at NuScale, it's a totally passive system. They were able to argue successfully that the emergency planning zone should be adjusted to reflect the design.
But there would be an emergency planning zone for any nuclear facility in any community, correct?
Yes.
And there'd be security issues and other things that the company must take into account to operate a nuclear plant.
Security is part of the requirements for operating.
Okay. According to the chart on page 32 of your testimony, I need to get myself there too, if you'll hold on. It's the drawbacks of having one screen versus many pages. So I appreciate Patience. Are you there on page 32?
I am.
Do you see the chart on that page,
Table 2, yes.
table 2, that has new nuclear near-term development activities?
That is correct.
Based upon that chart, I understand that initial development activities for the first of 2 units would cost $17 million between 2022 and 2024.
That is correct.
The ESP process in that same chart, which is the permitting process that you discussed,
Correct.
would cost $55 million between 2022 and 2024, correct?
That is what the chart says, correct?
Do you agree with the numbers in that chart?
Yes.
Has Duke already incurred the costs listed under 2022 in this chart?
We have not.
Okay. So would you incur those costs between a December 30th order of this commission and a December 31st end of year?
So our goal in developing this chart was to articulate the earliest that the dollars could be spent. We anticipate spending about $1 million this year.
Okay.
But the $5 million is there in case that we get direction from the commission earlier in the year and would move forward.
If you got indication, hypothetically, if the commission were to approve a near-term execution plan that included these procedures, would you move the 2022 column over to the right and spend $30 million in 2023? Do you know?
I think that the dollars would carry forward. I don't know the exact split between 2023 and 2024.
Is the timeline going to push another year?
I don't think it would push by a year, but no.
In the first 2 years for an ESP process with the Nuclear Regulatory Commission for one plant is then a $55 million commitment. Is that right?
So it's not for a plant, it's for a site.
For one site.
And it's for multiple technologies. So for example, just hypothetically, a site is approved for 4 units. The first 2 units could be one design. If the technology evolves and another design becomes superior in terms of how it fits into our system, the second, the third and fourth unit could be a different design. So the ESP has more versatility than a per site application.
So it's per unit or per site?
It's per site.
Okay, thank you for the
per unit application.
Thank you for the clarification. I appreciate that. But that 55 million associated with or listed in the chart on page 32 doesn't get you all the way to the NRC permit itself, does it?
No, we estimate that it's an effort somewhere between 50 and 75 million.
50 and 75 million
Correct.
per site.
Per site.
Okay. You anticipated my next question. Thank you. Now I need to skip ahead. In your testimony on page 31, lines 18 through 22, you testify that the ESP process takes 2 years with an additional 2 years for NRC review and approval, correct? Is that with every site or with every unit?
Site.
One further question about that testimony. You mentioned in that block, lines 18 through 22, table L3 of the carbon plan, which is on page 7 of Appendix L, as showing the estimated timeline for development. For clarity, and I've checked this, do you mean to refer to figure L3 on page 12 of Appendix L?
That is correct.
Okay, just for the record, I wanted to make that clarification. Thank you. That timeline shows that it is approximately 10 years from vendor path start to beginning fuel load and low power operation of a unit. Is that right?
That's a general thumb.
Okay. I would expect that there'd be efficiencies and redundancies built in once Duke has gone through this process with a few permitting processes for a few SMRs. Is that right?
There would be some efficiencies, yes.
So you might say you'd get better at it?
Yes.
But your initial estimate is a timeline of 10 years is that per site or per unit?
Per unit.
Okay. Any advanced reactor technology? Go ahead.
Let me correct that. So it would be per license. So the regulatory process would be, so for example, let's say that we were just focusing on 2 units that are mentioned in the carbon plan. you would be one licensing activity. So you, the ESP one time for multiple sites, an operating license, let's say for 2 units. And then, but the construction would be a unit specific activity.
Did you say that you would do an ESP one time for multiple sites?
Sorry, multiple units at a site.
Okay.
I'll slow down.
No, that's fine, because I'm
So-
asking questions in a very
So-
haphazard manner, so go ahead.
An early site permit is for a site. It can be multiple units.
Gotcha.
A license, it has to be for units at a site. It can be multiple units.
Gotcha.
So those are singular activities for the application you're looking at. Construction would be a unit-specific activity.
Understood. Any advanced reactor technology would be different from an SMR, right?
The technologies are different, correct?
So depending on the technology selected, there'd be a new learning curve for Duke and a new learning curve for the NRC for all that permitting process that we just talked about.
I think that the NRC is preparing and will likely see parallel permitting processes, not from Duke, but from the industry.
Okay. Do you have Appendix E of the carbon plan before you?
I do not.
I might need a copy for the witness, yes. I have my copy, but not for the witness. Bear with me, Madam Chair. May I approach the witness? Yeah. Hand you this document for your further page. I think it's already in the record since it was filed, so I don't think I need to introduce that as an exhibit, but if you could take a look at pages 35 and 36 of Appendix E. I'm sorry they're not stapled together, but council was good enough to give me a copy, so. Are you there?
Yes.
All right. Now I understand this is relates, Appendix E relates to quantitative analysis and modeling, and you did not perform the modeling that's represented in Appendix E, did you?
That is correct.
But what I want to draw your attention to is Table E3. I'm sorry, excuse me, I didn't, E39, thank you. Duke Energy discusses constraints that were placed on the model that limited annual selection of new nuclear units in Table E39 and total cumulative nuclear units in Table E40. Do you see those two tables?
Yes.
The total cumulative number of new nuclear units allowed in the model by 2048 plus on the bottom line there is 21. Is that right?
Correct.
That's 21 approximately 300 megawatt nuclear reactors, which is characterized in this chart as 14 SMRs and 7 advanced nuclears. Is that right?
That is correct.
That's for the modeling. Does Duke believe that it will be able to site 21 new nuclear reactors in and around North and South Carolina over the next 30 years?
So it's to meet net zero is a very challenging goal.
Mhm.
And if you the Nuclear Energy Institute recently sent a letter to the Nuclear Regulatory Commission estimating that nationwide there need to be 162 new gigawatts of nuclear energy to meet the goal.
Understood.
This is what we would need to do to be able to accomplish the goal.
I agree, and I
when
understand.
looking at the sites, we're looking for sites that can handle multiple units.
Does Duke believe that it will be able to site 21 new nuclear reactors in and around North and South Carolina over the next 30 years?
Yes.
What risks to that plan has Duke included in its analysis and decision to rely to such an extent on those new nuclear?
Objection, now we're in modeling. This panel is about the
Understood.
near-term development
I will direct
activities.
those. Thank you. That's a effective objection, and I'll withdraw my question. But I will reserve the right to ask that to the modeling panel on rebuttal. But you do have knowledge of the risks inherent in the construction and operation of a nuclear plant, don't you?
True.
Do you have the knowledge of the risks in siting a nuclear plant?
Yes.
Okay. And there are risks to an accelerated plan of bringing multiple nuclear reactors online in a short time frame, aren't there?
I think there's a technology risk. And I think the ARDP projects are doing a lot to address those. And so we're looking very closely at first of a kind plans. I think there's regulatory risks. I think that's why we're looking at environmental and siting to make sure we address those. I think there's construction risks. And so I think the technology risks and the construction risk in terms of schedule certainty, I think will be resolved after the first number of copies. Then I think it becomes a supply chain capacity.
So there's also a supply chain risk. There would be a risk with fuel supply too, would there not?
I think that is a risk that the Department of Energy is addressing.
You mentioned in your testimony that Duke is an investor in the Natrium project, correct?
No, we're not an investor. We're part of the project.
Part of the project. Natrium is a molten salt fast reactor. Is that right?
It's a liquid sodium.
Liquid sodium. Thank you. And it uses, you address in your testimony that it uses HALEU fuel.
Yes.
How do you pronounce? Is it
So it's an
HALEU?
acronym. It's HALEU.
HALEU?
It's high assay, low enrichment uranium.
It's true, isn't it, that the most ready source of that fuel, HALEU, is Russia
That is correct.
currently? Duke anticipates, though, that it will be able to overcome the risk of, well, let me rephrase this. The Ukraine war has placed a restriction on the supply of HALEU fuel, has it not?
So I'll answer the question that I think you're asking, which is capacity challenges for HALEU. So the Inflation Reduction Act included $700 million for DOE to pursue the domestic source.
Okay.
If you look at the current enrichment facilities, the technology is the same. You're just increasing the enrichment. So it becomes a capacity issue. And so one of the ways that DOE is addressing the capacity issue is to put a procurement in place to put a buy order in that will cause these enrichment facilities to increase their capacity and go through the licensing process, which is a higher enrichment, typically security requirements change. So we believe that challenge is being solved.
And Duke anticipates that it will be able to overcome those risks, right?
Correct.
Duke's experience in nuclear, highly trained staff and employees, and its leadership in nuclear technology makes it particularly suited to achieve this ambitious timeline. Is that your testimony?
That is correct.
So when Duke wants to get something done, it can get it done, right?
Objection. I just think it's a statement, but
Just asking if he agreed with the statement.
All right.
Cross.
I'm going to sustain the objection. Be more specific with your question.
And generally speaking, I'll pursue a different question. Generally speaking, which risk is Duke more able to overcome? One where the variables are within its control, or one based upon facts not within its control?
I believe one of the reasons that we're focusing on an early site permit is because those are within our control. And I believe we're recommending that we monitor the ones that are not in our control.
Okay. The effect of the war in Ukraine on supply of nuclear fuel is not within Duke's control, is it? Of HALEU fuel.
So two different questions. Is it fuel or HALEU?
HALEU.
It's not in our control.
But transmission constraints in its own balancing areas is likely to be something that Duke can overcome.
So I'm not here to testify for transmission, although transmission is an important part of siting.
Okay. Duke's position is that it should be a second entrant into this new nuclear market. Is that right?
I believe we've laid out a process for the commission to manage risks and focus on siting while the technology develops as a prudent course.
Your testimony and the testimony of your panel is that it would be prudent for Duke to be sort of an early adopter in the initial round of reactor projects once the test projects are complete. Is that
objection.
right?
I would ask counsel to point to where in the testimony it talks about being an early adopter.
Have I fairly characterized your testimony there, sir?
I believe that you used the statement second mover,
Mhm.
and I believe that's a fair characterization.
Thank you. That's a fair answer. Thank you. Did you is there a calculation of the levelized cost of energy anticipated in the carbon plan to be produced by new nuclear, or would that be a question best addressed at the modeling?
Modeling team. Okay.
Do you, as a person with experience in nuclear energy, expect costs associated with the deployment of new nuclear technology to increase or decrease in the next 15 years?
So are you talking about the cost to operate the existing fleet or cost to construct plants?
Cost to construct plants.
Cost to construct plants typically follows a pattern where they increase and then decrease.
And how long do they increase typically?
We have not gone through a cycle in recent times for me to make a projection.
And no one's gone through a cycle for the construction of an SMR, is that right?
That is correct.
No further questions at this time. Thank you.
All right, we'll start with SIGFR. We'll break for lunch at 12:45.
Thank you, gentlemen.
Good afternoon, gentlemen. My name is Christina Cross, counsel for SIGFR. I have the coveted spot right before lunch. I don't think I will get through my questions, but I will try my best. And these questions are going to be directed to the panel as a whole, so anybody please just chime in if you are the most appropriate person to answer the question. Duke's projected cost and rate impact estimates provided for the carbon plan do not include costs associated with Duke's plans to pursue 20-year subsequent license renewals of existing nuclear resources. Is that right?
That is correct.
How much does Duke expect these SLRs to cost?
So a subsequent license renewal application is a licensing process that provides the option to operate an additional 20 years. We expect them to cost between $45 and $50 million per site.
And what is the basis for that cost estimate?
The basis for the cost estimate is really what we saw during the initial license renewal phase. Process is similar, and so therefore we think those estimates are pretty reasonable.
Are you aware that Virginia Electric and Power Company, doing business as Dominion Energy Virginia, recently pursued regulatory approval for these SLRs for its Surrey Units 1 and 2 and North Anna Units 1 and 2?
I am.
At this time, I'd like to introduce an exhibit, and it's this pile right here. And I'll request permission from the chair to identify, to mark this exhibit as SIGFR 2 and 3, long lead time panel, direct, cross-examination, exhibit number 1, which is a copy of Dominion's recent petition of Virginia Electric and Power Company for approval of a rate adjustment clause, designated rider SNA, and case number PUR 2021-229.
All right, the document will be marked as SIGFR 2 and 3, long lead time panel, direct, cross-examination, exhibit 1.
Gentlemen, I'm going to direct your attention to the top of page 2 of the pleading itself, which is the 9th page of the document.
And
Now
I
that you-
apologize, page 9?
So it'll say page 2 at the bottom
Page 2,
of
got
the
it.
pleading, but it'll be the 9th page of the document. Now that you have this in front of you, can you please confirm that the current cost projection for the SLRs of these 4 Dominion Energy Virginia SLRs is currently projected to cost up to 3.9 billion.
Your Honor, I mean, Chair Mitchell, I would object. She's asked if he can confirm something that a piece of paper that's been put in front of his, him on the witness stand. He can read the document, but I don't believe he has any information that he could confirm the cost estimate.
Chair Mitchell, I'm happy to restate the question and simply ask the witness to read what the document says.
All right, I'll sustain the objection. Ask your question that way.
Thank you. So please, if you would, instead turn to the previous page, and we'll start at the bottom of that page. There's a sentence that begins with the word specifically. If you could please read that complete sentence into the record.
Specifically, the company seeks a determination that it is reasonable and prudent for the company to pursue the nuclear license extensions and related projects, which a current cost projection of 3.9 billion and approval cost recovery through rider SNA for phase 1 of the program, which includes those investments to date and for the following 3 calendar years, 2022 through 2024, totaling approximately 1.2 billion in support. So am I done?
Yes, thank you. That was the end of the sentence. Thanks. And if you could please turn to what will be shown as page 4, but it's really the 11th page of the document. Do you see where under section 3B, there's a section titled capital upgrade component?
Correct.
Okay. Can you please read paragraph 8 into the record?
In order to maintain the safety, reliability, and efficiency of the Surrey and North Anna units up to 80 years of operation, the company has identified 33 capital upgrade component projects that must be undertaken in addition to the SLRAs. The company created an extensive screening process in determining whether a project was necessary and eligible for the capital upgrade component of the SLR.
Has Duke determined whether capital upgrades will be necessary for the pursuit of SLRs for its existing nuclear fleet?
So we invest in our fleet to maintain its safety and reliability. And we make improvements, changes, component replacements based on aging and degradation as part of our capital budget. And that capital budget is, the viability of the plan is evaluated in the IRP periodically by the commission. And so the SLR provides an option for continued operation. It is not an option. It is not an attempt to gain additional capital dollars for the maintenance of the plant. I think Dominion has a different approach, and if you look at it, it talked about the SLRs and upgrade projects. And so I think our estimates for SLR would be the same. They're just including a lot of projects.
It's possible, is it not, that the Nuclear Regulatory Commission could conditionally grant SLRs to Duke Energy and require that the company undertake certain capital upgrade costs as part of the SLRs?
So typically, component degradation is something that's managed under the current operating license, and we're required to maintain safety on a daily basis. The subsequent license renewal looks at aging management. So it typically looks at concrete, buried cable, and do you have the appropriate surveillance programs in place to manage aging? So there typically are requirements in the license, but they're monitoring programs. They're not capital upgrades. Capital upgrades would be required under the existing license.
And so I believe you answered that question on, what happens on a typical basis, what happens usually. My question is it possible that the NRC could conditionally grant these SLRs contingent upon the company making certain capital upgrades to the nuclear fleet?
So I'm not in a position to say how the NRC would use its authority. I've not seen that.
So as you sit here today, have the companies definitively determined whether or not capital upgrades would be necessary in conjunction with pursuit of these SLRs?
I think what I tried to state in my testimony is that we look at the material condition of the plan and maintain it in accordance with using the annual capital budget. We've not looked specifically at the license renew period, but don't expect it to be any different than what we see on a day-in-day out basis now.
Okay, thank you. Switching gears. It is
Mr. Nolan, make sure you're in your mic, sir.
Thank you.
It's possible for any of the long lead time resources included in Duke's proposed carbon plan that project development activities may not ultimately result in generation plant that is placed into service. Is that correct?
That is possible.
And how will ratepayers be protected against the risk that long lead time project development activities may not result in new generation plant that becomes used and useful in the provision of electric service?
So I think what we're asking for in the carbon plan is for the commission to approve the decision to expend resources. But any recovery of resources would be in a future proceeding. I think exploring these options to look at the timing that they could be available and the best path to provide a low-cost option for the customer are valuable. Some paths may prove successful, some paths may prove not, and the commission will do a prudency review.
If I may add, just broader view. So as we propose here, there's a very specific set of development activities proposed for the commission's decisions. To your question, so we can progress down a path on time frame, a very limited time frame and actions. The companies support caps relative to those costs. And then a third strategy, again, holistically, is not to be a first mover, to be a second mover. We already have a Bad Creek 1 facility, so we've demonstrated its construction and operation. SMRs, again, we expect to be, will be a second mover along those lines. We already have companies that are out in front with signed contracts and direction relative to SMRs. Offshore wind, a number of projects from the Northeast on down the Atlantic that we'll be able to learn from and gain from those efficiencies.
Thank you for that. And would your answer be the same, gentlemen, if we're talking about how would ratepayers be protected from the risk of stranded assets?
So one of the things we're asking for is an early site permit. I think an early site permit has value on its issuance. It's approved for 20 years. It can be renewed for up to additional 20 years. It's technology neutral. And we've demonstrated in the carbon plan that it's not if, but when. And so I think that asset has value to the customer. And I only spoke to that one specifically because it's what's in the scope of this panel.
Thank you. I'm looking at the time, and do I need to?
Yeah, we'll go ahead and break now.
Thank you, Chair Mitchell.
All right, let's go off the record. We'll be back on at 1:45. You may continue.
Thank you, Chair Mitchell. Good afternoon again, gentlemen. Before the lunch break, do you recall that we were discussing ways in which ratepayers would be protected from risks like stranded asset costs, or the possibility that long lead time resources will not end up resulting in used and useful assets? You recall that? So, Chairman, is it fair to say that this commission has an integral role to play in ensuring that ratepayers are protected going forward?
Yes, absolutely.
And do you recall responding to, or the company responding to data requests pertaining to the issue of ratepayer protection?
I do not in my review for this panel.
Okay. At this time, I'd like to introduce Duke's response to public staff data request 7-10. And Chair Mitchell will request that this exhibit be marked for identification as SIGFR 2 and 3, long lead time panel, direct, cross-examination, exhibit number 2.
Okay, the document will be marked as SIGFR 2 and 3, long lead time panel, direct, cross-examination, Exhibit 2.
Thank you, Chair Mitchell.
And has a copy been provided to the panel?
Yeah.
I would just note for the record, this is, the responder is Mr. Jurek.
Gentlemen, is it fair to say that subpart B deals with this issue of how ratepayers will be protected in the context of long lead time development?
Yes.
Can you please read the answer to subpart B into the record?
Customers will be protected from stranded asset costs through the commission's oversight and review of the company's development activities in the manner deemed appropriate by the commission.
Great, thank you. Circling back to SLR costs, you testified before the lunch break that SLRs are expected to cost, you said between 40 million and 50 million, is that correct?
I did.
Is that per SLR or is that total in the aggregate?
It's per site.
Per site, not per unit?
Correct.
Okay, so per site then, there's 6 sites. We're talking about a range of between 240 million and 300 million?
So yes, the only reason I would hesitate is when we did original license renewal, we combined the Catawba and McGuire sites together as one application.
Thank you for that clarification. Is it fair to say that these SLRs are needed regardless of which portfolio is ultimately selected for carbon plan implementation?
That is correct.
Is it also fair to say that pursuit of 70% carbon emissions reduction, regardless of whether that occurs by 2030 or 2032 or 2034, would be technically and economically infeasible without the companies obtaining SLRs for their existing nuclear fleet?
That is correct.
Switching gears, it's correct, is it not, that 800 megawatts of offshore wind had to be forced into the Encompass model because it was not economically selected?
Objection, Chair Mitchell. This is a modeling panel question on how it was modeled, whether it was forced or included.
All right, I'll sustain the objection. You can ask the question in a different way.
If counsel for Duke will agree, I'm happy to just save this line of questioning for modeling panel on rebuttal.
To the extent it's in the rebuttal, I have no objection.
Moving on, with respect to Bad Creek 2, Duke began project development activities for that resource in 2019. Is that correct?
That is correct.
And it's Duke's position that the companies are legally required to own any offshore wind generation selected by the carbon plan. Is that right?
Objection, it's a legal question. I think there are extensive comments filed by the company, and it's also been asked and answered by this panel.
Chair Mitchell, I think it's, if I recall correctly, the commission indicated that this was an issue where issues of fact could be addressed in the evidentiary hearing and issues of law could be addressed in comments.
All right, well, I'll sustain the objection. You may ask questions of fact related to the issue.
Does Duke maintain this position even if utility-owned offshore wind generation does not result in the least cost resource mix?
Yes, if offshore wind is selected by the commission as a resource per the carbon plan, yes, the company would have ownership.
Okay, thank you. Nothing further.
All right, CPSA.
Thank you, gentlemen. Ben Snowden here on behalf of CPSA. Mr. Repko, just to recap, you've testified that the company is asking the commission to authorize cost recovery for development expenses for long lead time resources, correct?
For the three within my testimony, yes.
Right. So those include SMRs and offshore wind.
It does.
Okay. And Duke is requesting that the commission authorize cost recovery for those development costs, even if those resources are not selected in the carbon plan, right?
Your Honor, I'm sorry, I apologize. Old habits die hard. Chair Mitchell, I object. Mr. Repko did not state that we're requesting cost recovery. The companies are requesting approval of the decision to begin to incur the development activity costs.
Okay, well, I'll ask it another way. I think Mr. Repko is free to correct me if I'm wrong, but you make a good point. So, Mr. Repko, the company has asked the commission to authorize Duke to go out and spend money to develop these long lead time resources during the near-term execution plan period, right?
Correct, to begin incurring the costs associated with the development of them.
Okay, thank you. And again, that is, even if the company, well, I tell you what, why don't I go back to the petition? And this is page 16 of the company's petition for approval of the carbon plan. And I can just read it if you want. It's in paragraph 2C, Romanet 3, the company is asking the commission to make a determination that in the event the long lead time resources are ultimately determined not to be necessary to achieve the energy transition and CO2 emission reduction targets of 951, such project development costs will be recoverable through base rates over a period of time to be determined by the commission. Is that right?
That's correct.
Okay, thank you. And at this time, it is not clear whether small modular reactors or offshore wind will be selected by the commission as part of the carbon plan. Is that right?
The commission has the discretion to select the resources per the plan.
Okay. And the company has estimated the amount of development costs it plans to incur on SMR development during the near-term execution plan as, is that $72 million? Is that right?
That's correct.
Okay. And it's and I don't want to go into your rebuttal testimony, but just to acknowledge, the company has indicated that it would agree to a cap on those near-term development plan. I'm sorry, those near-term development costs for SMRs of $75 million. Is that right?
That's correct. The company supports caps for all the three resources for long lead items.
Okay. Has the company estimated the development costs that it would incur on SMRs by 2030?
I'd have to ask Mr. Nolan if we have assessed that.
So the modeling panel has assessed the cost. I can describe the process.
Okay. You can if you want to, but there's no need. Thank you. And then with respect to offshore wind, the company estimates that the total cost of near-term development activities during the period of the near-term execution plan is about $317 million. Is that right?
That's correct.
Okay, and there's a cap the company has agreed to on those costs as well, right?
We have, yes.
Okay,
Well, we propose.
okay, and what's that cap?
That's within my rebuttal testimony, if you'll give me just a moment.
I believe it's on,
Thank you.
page
Found
16
it.
of your rebuttal testimony.
And your question was relative to offshore wind? is that
Yes, sir.
correct? So the proposed cap is 325 million.
Okay, thank you. Mr. Nolan, I have a couple of questions for you. You have been with Duke since 2006, is that right?
That is correct.
Okay, and you've testified that you are familiar with the risks involved in constructing nuclear facilities, correct?
I am.
Okay. Is your perspective on the risks involved with developing nuclear facilities informed in part by Duke's experience with Lee Nuclear Station?
It is.
Okay, and were you involved in the development of Lee?
I was.
Okay. At this time, I would ask to mark for identification CPSA Long-Term Resources Panel Direct Cross-Examination Exhibit 1.
Okay. The document will be marked as CPSA long lead time resources panel direct cross-examination exhibit 1.
Yeah. My apologies for the delay in getting those handed out. So, Mr. Nolan, I'll represent to you that this is an article from the Charlotte Business Journal about Duke's abandonment of the Lee nuclear station. Do you see this?
I see it.
Okay. And you have personal knowledge of circumstances related to Lee?
I was on the project between 2007 and 2010.
Okay, so prior to its cancellation?
Prior to its
Okay.
cancellation.
Were you familiar with the circumstances surrounding its cancellation?
Generally.
Okay, thank you. Mr. Repko, were you involved with the cancellation of Lee?
No, not directly.
Okay, all right. So I'll ask you guys to speak up based on your personal knowledge here. Just want to direct your attention to page 2 of this article, right near the top where it says, to ease impact of Lee's costs on the rate hike, Duke wants to spread recovery of the $368 million over 12 years. Wait, and actually, I'm sorry, strike that. Let me back up. I say the proposed Lee nuclear facility. This was not a facility that was ever built, correct?
We have a combined operating license for it. We did not enter the construction phase.
Okay, so Duke requested the permission of this commission to cancel the nuclear project, correct?
I don't have that knowledge.
Okay, so you're not aware whether it was canceled?
I know we made a decision not to build it. I couldn't answer your question.
Okay. So going back to the exhibit, it says Duke wants to spread the recovery of the $368 million over 12 years. As I interpret that, the company requested rate recovery of $368 million in development expenses associated with Lee. Does that sound right to you?
I believe that is correct.
Okay. And then in the next page, it says the cost allocation would be North Carolina's share of the $541 million Duke spent to date on the project. Does that sound right?
What page?
I'm sorry, this is the same page in the next paragraph after it says $500 million spent.
Okay.
Okay. So does that $541 million in total development costs sound right to you?
It's approximately right.
Okay. Would you agree, just based on your experience with Lee, that the company originally received authorization from this commission to incur $125 million in development expenses on the Lee project?
I'm not aware of that fact.
Okay, okay. And are you aware of whether this commission ever capped further development expenses for the Lee project?
I'm not aware.
Okay, thank you. Mr. Repko, are you aware of that?
I'm not.
Okay, thank you. Okay. Mr. Nolan, would you agree that this commission ultimately authorized the recovery of approximately $347 million in development costs for Lee?
I believe that is correct.
Okay. And the South Carolina Commission authorized recovery of approximately $125 million in development costs for Lee?
I can't attest to the dollar value, but I believe that we did recover those investments.
Okay, thank you. Do you recall that the Lee nuclear station as designed would use a new reactor technology that was developed by Westinghouse?
The AP1000.
Right. And so in your role at Duke, you were familiar with the AP1000 design?
I am.
Okay. And would you agree that at the time, AP1000 was an innovative new design that promised to simplify construction of nuclear facilities?
AP1000 was one of the first designs to include passive features, so it enhanced the safety and yes, it was a new design.
Okay. Was it expected to reduce the cost of construction of nuclear facilities?
I don't believe so.
Okay. Would you agree that Duke was one of the first utilities in the United States to attempt to develop a reactor with that technology?
I believe we were the second utility to submit a license application.
Okay, so you were a second mover on that AP1000 reactor?
No.
Okay. Would you and I'm using Mr. Snyder's nomenclature here. He talked about being an early adopter of technology. Would you say that Duke was an early adopter of the AP1000 technology?
No, I think our actions were prudent, right? We decided that we needed to address the regulatory issues. So we pursued a combined operating license. We decided we wouldn't go to the field unless we had a detailed design and a approved license from the commission.
Mhm.
And we didn't go to the field because we never got those two criteria. And at some point in time, the economic conditions that favored new nuclear changed.
So you attribute the failure of or the cancellation of the project to a change in economic conditions?
It was one of the factors.
Okay. Would you agree that the reason the project was canceled was that Westinghouse, which had designed the reactor, declared bankruptcy because of losses taken by its nuclear division?
Chair Mitchell, I believe this article gives the company's reason and answer to that question, and it speaks for itself. There's a quote on page 3. So Mr. Nolan has been clear that he was involved in that project early on and not at the time of the filing with the commission. So we could speed this along if.
Sure. Yeah, that's fine. I'll withdraw that. And Mr. Nolan, I'm not trying to, just to be clear, I'm not trying to demonstrate that the company was doing anything imprudent with regard to development of Lee Nuclear. I guess the question I have to you is, even assuming the company acts reasonably and prudently, would you agree that there's a significant risk with the new technology that it may ultimately not be available?
So I believe that development activities that we laid out are prudent, reasonable actions. I think addressing regulatory risk is a right first step. I think the dynamics that are driving the focus on AP 1000 are different than the dynamics that are focused on climate change.
Okay, thank you for that. Let me ask you another question. Is the company planning to ask, if you know, is the company planning to ask the South Carolina Public Service Commission to authorize the recovery of development costs for SMRs or offshore wind, regardless of whether they are selected for the carbon plan?
I don't know at this time.
Okay. Would you agree, Mr. Repko, that if Duke didn't ask the South Carolina Commission for that, or if the South Carolina Commission did not agree with that, either Duke's shareholders or North Carolina ratepayers would be on the hook for those costs?
That would be likely.
Okay, regardless of whether these resources were ultimately included in the carbon plan.
Correct.
Thank you. Mr. Nolan, would you characterize SMRs as a mature technology?
I would say the light water SMR are very similar to the reactors that we operate today.
Okay. Would you characterize SMRs as a mature technology?
No.
Okay. And Duke is planning to deploy SMRs on an aggressive schedule, right?
The carbon plan lays out an aggressive schedule for nuclear development.
Okay. Would you agree that Duke is trying to deploy SMRs as soon as it can?
I would say I think we laid out a prudent action to learn from others.
Okay. Do you believe that SMRs will be a mature technology when Duke starts constructing them, assuming it does?
I believe when we say we want to be a second mover, we are indicating we want to learn the lessons from the initial plans.
Okay. Would you agree that there is a lot of interest in the utility sector in SMRs?
Yes.
Okay. And would you agree that a lot of utilities are looking to deploy SMRs?
That is correct.
Okay. So you would expect there would be a number of lessons learned as these first utilities begin to deploy SMRs in the U.S.?
I believe so.
Okay. Would you expect that there would be a number of technological innovations in the early years of SMR deployment?
I think the advanced reactors have some technical hurdles that they have to get through, and I think the Department of Energy funding the ARDP projects is a way to accelerate their deployment.
Okay. Well, with respect to SMR specifically, would you expect that the technology will be refined as SMRs start to go online in the U.S.?
I think the technology is known. I think the challenge is in making sure it is built efficiently and effectively.
Okay. So when you say the challenge is making sure it's built efficiently and effectively, are you referring to cost of construction or something else?
The cost and time.
Cost and time. So what I hear you saying is that there will be a challenge in keeping SMRs on schedule and on budget. Is that a fair characterization of what you're saying?
I believe what I'm saying is that we laid out an approach that will allow us to learn from the first movers.
Okay. Would you agree, Mr. Nolan, that there are significant risks associated with the development of SMRs?
Objection. It's a vague term, significant.
Okay. Would you agree, Mr. Nolan?
Mr. Snowden, do you want to respond to the objection and then let me rule on it?
I can simply rephrase my question.
Okay, go ahead.
To make it easier. Mr. Nolan, would you agree that there are risks associated with the development of SMRs?
Yes.
Okay. And those would include the risks that the technology will not be available when it is planned for? Do you agree with that?
Could you be more specific what you mean by that?
Sure. Sorry. Would you agree that if Duke were to plan to add SMRs to its portfolio in, say, 2032, there is a risk that SMRs might not be available for deployment at that time?
I think there will be SMRs available at that time. I think the 2032 schedule is aggressive.
Well, let me reframe my question then. Do you think it is possible that Duke will not hit that timeline?
I think it's possible.
Okay. Do you think, Mr. Nolan, or would you agree that there is a risk that the prices of SMRs, or rather the cost to construct SMRs, will be higher than Duke projects?
There is uncertainty in the pricing.
Okay. Would you acknowledge that there is a risk that SMRs might not ultimately be least cost resources?
I think in order to meet net zero climate change, nuclear really has to be part of the solution to have a safe and reliable grid. So I think it's really a question of when and not if.
Okay. But you would agree that there is a substantial risk that the cost of SMRs may be higher than is projected by Duke?
Objection, Chair Mitchell, to the use of the word substantial. It is vague again.
I can attempt to quantify the risk, but I fear that I'm asking Mr. Nolan to testify sort of based on his subjective, his experience with developing nuclear projects. I guess I would ask Mr. Nolan to use the word significant as he would define it himself. I mean, do you have trouble understanding I'm sorry, I shouldn't ask a question, but I think.
Can you ask the question, Mr. Snowden,
Yes.
without using a word that's subjective?
Sure.
Can you just figure out a way to restate the
Sure.
question?
Mr. Nolan, do you think it's possible that the costs of SMRs would exceed 125% of the costs that are projected in Duke's carbon plan?
I'd say that there's uncertainty in the cost, and that's why the lead projects are important.
Okay, thank you. Notwithstanding these risks, do you believe that it is appropriate for the commission to authorize Duke to undertake these early development activities on SMRs?
The early development activities are for an early site permit, so yes, I believe it's appropriate. And the reason I believe it's appropriate is the value of that permit is not dependent on time.
Okay. Okay, those are all the questions I have. Thank you.
All right. Environmental Working Group.
Good afternoon, everyone. Can you hear me? My name is Andrea Bonvecchio. I'm here on behalf of the Environmental Working Group. I hope you all are doing well today. My questions are relating to nuclear, and we've already covered a lot of ground, Mr. Nolan, so I just have a couple of clarifying questions for you. And so if you will please turn to page 28 of your testimony. And so towards the bottom of page 28 and on page 29, you identify 4 new nuclear technologies and state that these 4 are scheduled to be built on 5 different projects and are expected to be operational in the next decade. Did I read that right?
Yes.
So just to be clear, the 4 designs that you identify on page 29 are also identified in Appendix L of the company's carbon plan, correct?
They are identified on page 9. I don't have Appendix O in front of me.
Do you have a copy of Appendix L? Just.
I do.
Great.
Did you say L or O?
L.
Oh, I have it.
Okay.
Sorry, I misunderstood.
I'll refer to it later. And so the companies expect that it could have an SMR unit up and running with an in-service date of mid-2032. Is that correct?
That's in the carbon plan, yes.
Okay. And we'll get into these designs specifically in a moment, but other than the NuScale Voyager or the GE Hitachi BWRX 300, which are both SMRs, are there other designs that Duke Energy is considering for that proposed first SMR planned in mid-2032?
So we haven't selected a technology. We have identified that light water SMRs have less of a technical leap. and would be prioritized. Those are not all the light water SMRs that there are, but we put these in place because of the development activity underway or scheduled for these designs.
Sure. And I understand that a technology has not been selected, but other technologies outside the scope of these four that you've identified in your testimony are being considered.
Correct.
Do you happen to know any of those designs off the top of your head?
So we are continually assessing all the designs. We listed these four as the leading candidates.
And do you happen to know what the expected timeframes are for those other designs that are in consideration to be in commercial operation?
I don't believe any of them have a expected operation date.
So, Mr. Nolan, I'd just like to ask a few questions regarding the specific SMR designs that you've identified. And you testified earlier, but just to be clear, no SMRs have been built in the United States, correct?
Correct.
And they haven't been deployed at a commercial utility scale, correct?
That is correct.
So one of the technologies that you identify in your testimony on page 29 is the GE Hitachi BWRX 300 SMR. And on line 4, you state that Ontario Power Generation is building a BWRX 300 at its Darlington site in Clarington, Ontario. But I just want to be clear, is the BWRX 300 SMR currently being built, or are there plans to build it?
I think there are plans to build it.
Okay. So is it fair to say that there are plans to build it and it hasn't been built because it hasn't been certified by the NRC?
So that plant will be in Ontario. So it would be the Canadian regulator that would give that license.
Thanks for clarifying that. And so jumping to page 37 of your testimony, you mentioned that on line 6 through 7, you mentioned that the BWRX 300 SMR is based on the GE Hitachi Economic Simplified Boiling Water Reactor design. Is that correct?
That is correct.
And you also say that that design has already been licensed by the NRC as an improved design over the large light water reactors in operation today. Is that correct? That's on line 7 through 8.
So yes, it is certified. It has a design certification.
Okay,
And it has passive features.
great. That was actually one of my questions. But so was that predecessor design ever constructed?
No,
So it was never put in operation for utility in the United States?
that is correct.
And if you'll go back to page 29, sorry to make you jump around. Another SMR design, another SMR design that you identify is the NuScale Voyager SMR, correct?
Correct.
And specifically, you refer to the 77 megawatt NuScale design that the Utah Associated Municipal Power System plans to deploy in 2029. Is that right?
That is correct.
But would you agree that NuScale previously raised its SMR design's capacity or power output from 50 megawatts, then to 60 megawatts, then to 77 megawatts?
They have a design certification for the 50 megawatt module, and they're pursuing an SDA for the 77 megawatt module.
Okay. So could we agree that as originally submitted to the Nuclear Regulatory Commission, NuScale proposed an SMR design with modules producing 50 megawatts?
Correct.
And so given your experience in the nuclear industry, does increasing of reactors generating capacity lower or raise any costs related to that reactor, such as capital costs or levelized costs of electricity?
I think there would be some incremental increase in the cost of the design because of the power output increase.
Okay. And so now I will refer to Appendix L. Specifically on page 8, there's a table labeled L4. Are you there?
Yes.
Thank you. So would you agree that this section of table L4. So L4, it has, it's labeled leading advanced nuclear reactor technologies. Do you see that? And then I'm looking at the small modular reactor section. And I'm looking at the first section, which is referring to the new scale Voyager 6 and Voyager 12. Do you,
Sorry, can you pause?
Yeah.
I was looking at figure L4. You're
I'm
talking
sorry if
about
I said
table-
figure, table L4.
Page 8. I'm there.
Thank you.
Sorry.
No, you're fine. So would you agree that this section of table L4, right under small modular reactors, is referencing the project that plans to deploy the 77 megawatt new scale design?
Yes.
So would you agree that since this section of table L4 is referencing the new scale 77 megawatt reactor design, stating that it received a design certification approval in August 2020, in that second bullet, is not entirely accurate?
NuScale did receive a design certification approval. It is not for the 77 megawatts, so those two are not aligned. But I think what we're trying to say is that there's a degree of confidence in the regulatory process because the delta between a 50 megawatt design and a 77 megawatt design is small compared to the overall approval.
Okay, thank you for clarifying that. So because the project that is identified is proposing to deploy that 77 megawatt new scale design, would that design have to undergo a separate review process by the Nuclear Regulatory Commission?
So there's three ways you can enter the Part 52 licensing process. You can use a certified design, an SDA, a standardized design approval, or a site-specific application.
Okay, so would you agree, though, that neither of those processes would constitute approval to build or operate a reactor?
It would take time to get an operating license.
Okay, so that's the
For any
sort of
of
the second.
For any of the designs.
Okay. Okay, and I just want to move on to the advanced reactors.
Mhm.
And I just have two questions. So one of the advanced reactor designs identified in your testimony is the Natrium reactor by TerraPower and GE Hitachi.
Correct.
And according to your testimony, that design is scheduled to be operational in 2028, correct?
That is correct.
You also state on page 29, on line 15 of your testimony,
All right, page number.
page 29,
All right, that's in line 15, all right?
line
I
15,
got
yeah.
them inverted. Line 15.
Yeah, thank you. So you state there that TerraPower is building a Natrium plant for Pacific Core in Kemmerer, Wyoming. But again, just to be clear, is the Natrium plant currently being built, or are there just plans to build it?
So the activities include siting, developing the license application, and designing it. At some point in time, they will enter the construction phase.
Okay, so actually constructing the
They
reactor
need to get a
itself.
construction permit from the NRC before they can build it.
Okay. All right, and then I just have a couple of questions about the near-term development activities
Okay.
for new nuclear.
What page?
So on page 31, on lines 5 through 14, you provide a timeline of near-term actions. Is that right?
Correct.
And between 2022 and 2023, according to this timeline, 2 near-term development activities include performing a new nuclear technology selection, that's on line 9, and the selection of a company that will construct the new nuclear technology.
Correct.
Is that accurate? Thank you. And this was pointed out earlier today, but there are costs associated with these activities, correct?
Correct.
And in this timeline of near-term activities, according to your testimony, is to support the future availability of SMRs, specifically to achieve a mid-2032 in-service date for an SMR. Is that right?
They are to advance the deployment to create an option.
Okay. So would you agree then that based on this timeline you provided, Duke Energy plans to select a design and company well before the technology is expected to be in commercial operation?
I think we are continually monitoring the technologies. Our hope is that to support the 2024 version of the carbon plan, we'll do a check and adjust and update the commission on the technologies and their viability. And then I can't predetermine what that will be.
Okay.
I just know we'll do the work in 2022 and 2023 to be ready for 2024.
Got it. So if you're checking and adjusting and you're sort of monitoring the development of these technologies, is it possible that those actions will likely happen after 2024? Specifically selecting the new technology and choosing the technology and company to build the first plants.
So we laid out our best view of the timing of activities, and really it'll be the pace of development of those technologies that will lead to that answer.
Okay. And if any of these activities were to happen outside of the 2022 to 2024 timeframe, wouldn't you agree that those activities would be more appropriate to request during the next carbon plan proceeding or update?
So I think each time we update the carbon plan, we'll give the commission the best available information. I think our approach has been twofold. I think we've given the commission the earliest date that we think we could deploy a technology, which is mid-2032. When you look at the projects that we described, we did that with the intent of showing the reasonableness of that, but yet the aggressiveness as well. At the same time, we've also laid out an approach that manages risk, and that's to focus on siting while those technologies develop. Admittedly, the technology development is out of our control, and so we'll just have to respond to the events as they develop.
Thank you, Mr. Nolan. And so as part of the near-term development activities, do the companies intend to, and again, I'm just referring to those two on line 9 and on line 11, do they intend to select just one technology, or does it intend to select multiple technologies?
I can't predetermine whether it would be a narrowing of options or it would be a focus on one.
Okay. And I'm just looking at I'm turning to page 32 of your testimony, and there's table 2. And I'm looking at the section, so it's the second row where it says develop COL application. That's a combined
Operating license.
Thank you. So if there are costs associated with that, but the companies don't know which technology they're selecting, does that mean that multiple COL applications would have to be developed?
No.
No, just one.
There are site-specific portions of the COL that can be developed independent of the technology selection. The majority of it needs the technology.
Mm-hmm.
But what we would do is we would take the license applications from the lead plants and be ready to assimilate that into a license application once the technology is selected.
Okay. Thank you, Mr. Nolan. And I think I have just a couple more questions for you. At the beginning of this panel's testimony, Mr. Repko identifies the performance of a new nuclear technology due diligence review as a near-term development activity. Are you familiar with the statement?
Yes.
Well, Mr. Nolan, if one of the activities is the performance of a due diligence review, could you explain what that due diligence review could look like?
For a technology?
For new nuclear.
Okay. So we are looking at the various aspects of the design, looking at the risks associated with those, and then participating on the utility advisory panels participating in the design reviews, doing deep dives with the technologies under our NDAs, and narrowing our view of what the most viable technologies are.
Thank you, Mr. Nolan. And do you think that this review, you mentioned risks, do you think that it should include an assessment of the risks of water availability during extreme heat events?
So we do that as part of the siting. That would be done under the early site permit.
Great. And are you aware of discussions or documentation about these types of climate-related risks in the company's carbon plan, specifically related to new nuclear generation?
Yes.
Could you point me to where in the
So
carbon plan that's
risks associated with new nuclear generation?
specifically climate-related risks?
Oh, no. Sorry, I misunderstood.
Oh, you're fine. And just have one more line of questioning. And I just want to briefly clarify the proposed development of an early site permit and its estimated costs. And so it may be helpful to have Appendix L out, specifically page 12, figure L3.
Yes.
Okay. So the companies are seeking approval of pursuing the development of an early site permit that would potentially be submitted to the NRC in 2024, correct?
Correct.
And this would be to have an SMR operational by 2032, correct?
Correct.
And this early site permit would be for just one site, correct?
Correct.
And an early site permit takes approximately 2 years to develop, according to your testimony, correct?
Correct.
Are you aware that every portfolio in the company's carbon plan reflects 2 SMRs being installed by 2035?
Correct.
So if 2 SMRs are anticipated by 2035, is it possible that that may require submitting 2 early site permits to the NRC?
Unlikely. We would likely put both units at the same site.
Okay, that answers my question. And I believe that's everything I have for you. Thank you for your time.
Thank you.
All right, NCSEA.
Thank you. Good afternoon, gentlemen. Taylor Jones for the North Carolina Sustainable Energy Association. Mr. Nolan, if I could keep you in the hot seat, I'll try not to retread a lot of this territory. I think you've established both in response to Mr. Snowden and in your testimony that in your various roles with the company, you've managed planning and project development activities for new nuclear interests. Is that a fair characterization?
I was involved in the licensing of the Lee nuclear site.
Thank you. And if I could ask you to just help me understand some of this reactor design terminology. Under the umbrella of a light water reactor, there's a pressurized water reactor that's sort of a subset of the light water reactor designs. Is that correct? And the Westinghouse AP1000 reactor was a pressurized water reactor and a type of light water reactor.
Correct.
At the time Duke Energy Carolinas proposed the Lee nuclear project, did you consider the Westinghouse AP1000 reactor design to be a proven technology?
I think we had confidence in it, but it was yet to be proven.
Okay. Is it fair to say that it's the practice of at least the team responsible for nuclear generation proposing projects for development that you only propose new projects when you believe the technology to be viable?
I believe that's fair.
Oh, thank you. And you've testified that the companies believe small modular reactors to be a proven technology at this time.
They're based on a proven technology.
Okay, thank you. Just a few more questions. On page 24 of your direct testimony, I believe it is, you speak to the company's track record of operating the nuclear facilities in its fleet. And you testified that, you think this information is relevant to the commission's consideration with respect to the company's requested relief for SMR development. I'm wondering, Mr. Nolan, can you tell me the last new nuclear facility either of the companies developed and brought online?
Harris was the most recent plant brought online.
Subject to check, do you agree the commercial operation date for the Harris unit was in 1987?
I don't know the exact date, but subject to check.
Okay, thank you. And since that time, the company has not successfully brought any new nuclear generation online in the Carolinas.
That's correct.
Thank you. Nothing further.
All right, NC Warren.
Thank you, Chair Mitchell. All of my questions have been asked.
Thank you, Mr. Quinn. All right, Sace. Tech customers.
Good afternoon, gentlemen. My name is Craig Shower, and I represent the tech customers. Just one moment, I wasn't expecting to go this early. Here we go. Earlier, I believe you testified in response to questions from other counsel that the company's acquisition of the Carolina Long Bay lease from the Duke affiliates is necessary for the companies to make sure the wind lease development progresses at a pace sufficient to meet the expected timelines in the carbon plan. Is that an accurate paraphrase of your testimony?
That's correct.
Okay. And you also testified that the Duke affiliate is currently developing the lease?
It is progressing along those lines, yes.
Is the Duke affiliate currently developing the lease at a pace that is sufficient to meet the timeline in the carbon plan?
I don't know.
Right. If the companies do not know if the Duke affiliate is developing the wind lease at a sufficient pace, then why do the companies believe that acquiring the lease will allow the companies to achieve its execution plan for offshore wind?
So that we can have direct oversight and accountability to that.
So is it your testimony that if the companies, is it Duke's position that if the companies do not own the lease, there's no guarantee that the lease will be developed at a sufficient pace in order to meet the timelines of the carbon plan?
Yes, that's correct. That's what I'm saying. If the development continues in the commercial affiliate, there's really not an incentive to accelerate that development to meet, an aggressive timeline for the carbon plan if the commission chooses offshore wind as an option.
Should the Duke affiliate not transfer the lease to the companies, do you know what it will do with the wind lease?
So it is likely that, some progression of development would, and they could very well be looking for an off-taker, to sell the lease.
Earlier, I also believe you testified that Duke favors the self-development of offshore wind over build-own transfer of offshore wind because self-development was more straightforward. I believe that's the term you used.
Objection, Chair Mitchell. I don't think that might be a summary of a number of different questions together, but I don't believe that was Mr. Repko's testimony.
Chair Mitchell, I'd ask that the witness answer the question and not opposing counsel.
All right. Do you have a response to her objection, though?
Yes, Chair Mitchell. It was a question seeing if I accurately paraphrase his testimony, and I think it's a fair question for her to answer.
All right, I'm going to overrule the objection.
Right.
Ask it again so he understands what you're asking.
Thank you. So earlier, I believe you testified that Duke favors the self-development of offshore wind over build-own transfer of offshore wind because self-development was more straightforward. Do you recall that testimony?
I don't.
Okay.
If I use those words, what I was referring to in terms of self-development is that we would have the project management oversight of that. We would procure the necessary expertise relative to engineering, procurement, construction of offshore wind. And we would do that through, bid events, RFPs of that nature. But we would own the project management and oversight of that.
So to elaborate on that, what are the advantages of self-development of offshore wind versus build, own, transfer of offshore wind from Duke's perspective?
Well, you could have a model of build, own, transfer under that development model where the company has that oversight of the project management activities to ensure it's progressing and they're aware of the status of those. But again, like an EPC, you could do that under a BOT model, build, own, transfer.
You just used two acronyms that I'm not familiar with, so I'm
sorry.
just going to move on. That's fine.
BOT, build, own, transfer.
Okay, thank you. And then EPC, could you define that for me as well?
Engineer, procurement, and constructor.
Okay, and can you explain to me what that is?
Yes, so you could acquire an experienced project developer and constructor that would do the actual engineering, the procurement of the materials, and literally construct the facility, the project. So you could bid that out each individually, or you could bid that out in terms of one company or entity that would do all three.
So at this stage, does Duke have a preference for what style or what form of development it would choose for the offshore wind lease?
Not at this point, no.
Are you aware of the price at which Avangrid purchased the Kitty Hawk wind lease?
Yes,
Is it approximately $9 million?
yes,
Okay. And Duke's affiliate acquired its wind lease for $155 million. Is that correct?
that's correct.
If Avangrid was willing to sell its lease for, say, $90 million, then acquiring the lease from Avangrid would save ratepayers approximately $65 million as compared to the companies buying the wind lease from the Duke affiliate. Is that correct?
Yes, but as I stated previously, Duke assessed all options for a lease prior to participating in the auction. The pursuit of options for a lease included discussions with Avangrid Renewables, but those discussions were under a confidentiality agreement.
So have the companies made an offer to Avangrid to acquire Avangrid's wind lease?
Chair Mitchell, at this time, as Mr. Repko has represented, there have been discussions with Avangrid that are subject to a non-disclosure agreement. We are allowed to say that there is the existence of a non-disclosure agreement, but unless we go into confidential session, which we are absolutely willing to do, we're not allowed to say any more on the public record. And we have no objection to going into confidential session. I just wanted to be clear.
If I could have just one moment to think of whether or not my line of questioning is worth going into confidential session, I apologize. So all right, so Chair Mitchell, I think I can ask a question that would avoid the divulgence of confidential information.
All right, proceed, please.
All right. If the companies never attempt to acquire the Avangrid wind lease, how would the companies demonstrate to the commission that the company's purchase of the Carolina Long Bay lease from the Duke affiliate is the least cost means of securing offshore wind?
Chair Mitchell, I appreciate council's efforts. In order to actually answer this question, the information would need to be in confidential session pursuant to the confidentiality agreement that the parties have signed.
Oh, I actually think Chair Mitchell, if I may, I believe it could be viewed as a hypothetical. In the hypothetical situation, if the companies were to never have attempted to acquire the Avangrid wind lease, how would they demonstrate lease costs to the commission?
Chair Mitchell, I I don't think it's appropriate to answer a hypothetical when there's a reality that's also available to respond to. I don't know the value of answering it hypothetically, and he is under oath.
All right. So let's do this. Let's go into confidential session if, so that you can get your question answered.
Thank you, Chair Mitchell.
Let's turn off YouTube, please, and we will clear the room. If you are not under a confidentiality agreement, exit, and please do so quickly. With cross-examination of the long lead time resources panel, we're going to defer any questions that may that may go to confidential information until rebuttal, until this panel is up for their rebuttal testimony. At this point in time, we're going to go to Walmart to ask its questions, and then we'll go to the public. We'll hear from the public staff.
Thank you, Chair Mitchell. Good afternoon, gentlemen. My name is Carrie Grunman on behalf of Walmart. I have a few questions that I believe are probably for witnesses Repco and is it Pompey? Am I going to Pompey?
Pompey.
Thank you. And it relates predominantly to offshore wind. As it relates to the near-term activities, the company's proposal is for the commission to essentially approve the company's acquiring the Carolina Long Bay lease from Duke Energy Renewable Wind LLC. Is that correct?
That's correct.
And for purposes of my questions, can we agree that Duke Wind is the affiliate, and I'll just call it that, Duke Wind moving forward?
I'm fine with that.
Okay. And if we look at table 3 on page 49 of your testimony, you're proposing to acquire that lease for $155 million plus the $200,000 in ongoing year-to-year lease costs.
That is correct.
And $155 million is the cost that Duke Wind paid to the federal government when it won the auction for that lease.
It was the winning price at the auction, the lower of the two prices for the two parcels. Correct.
And am I correct that the reason that DEC and DEP are able to acquire that lease at cost is because of obligations of the nature of the affiliate transaction that obligates it to be procured at the lower of cost or market?
That's correct.
And so you've indicated that Duke Wind is pursuing additional development activities related to the SAP. Is that correct?
That's correct.
And to the extent Duke Wind incurs those costs, would you reimburse Duke Wind for those costs when you or if you acquired the lease?
I had understood that in the affiliate transfer, those costs would be included with that. So that's my understanding.
But to the extent that the Duke Wind expends costs associated with whether it be the SAP, the site assessment plan, or the COP, if DEC or DEP acquires that lease, they would essentially pay back Duke Wind's costs. Is that correct?
At cost, correct.
At cost. And it would be the lower of cost or market. Is that fair?
That is correct.
Now, by contrast, if DEC or DEP is the holder of the lease and DEP or DEC incurs the costs with respect to the COP or the SAP, are you following me so far?
I am.
Those costs expended by DEC or DEP would be subject to the company's ability to earn a return, would it not?
I believe so, yes.
Which is not a possibility if those costs are incurred initially by Duke Wind, correct?
Correct.
Mr. Pompey, you discussed with counsel for Avangrid, and I want you to correct me if I get this wrong, but I think you said that the capital expenses associated with the additional length of underground cabling that would be needed to connect Kitty Hawk to the company's preferred point of interconnection at New Bern, that essentially the costs of that cancel out any benefits associated with Kitty Hawk having a 43% net capacity factor versus the Duke Wind Carolina Long Bay lease net capacity factor of 36%. Is that correct?
There are a couple of corrections there.
Please.
You said underground, and what we're referring to is subsea. It is underground, but it's below the
further
seabed.
underground.
Well, it's not really. It's just a difference of offshore versus onshore underground or something like that. Just
Understood.
wanted to clarify. So the subsea to the landing point, from the landing point to New Bern. All of that, yes, double. The capacity factors, as I stated earlier, we don't agree that Carolina Long Bay is a 36% capacity factor because the work hasn't been done yet. And that's specifically what we're asking for, is to do that work. We believe at this point that it's unknowable whether that capacity factor is 36% or higher.
Is that something that that Duke Wind would study in the course of either the SAP or the COP or other developmental activities?
Yes, so the the site assessment plan gets submitted, and then the survey work, including the meteorological buoy that goes out there to collect wind data.
And all of that data is needed, is it not, in order to submit the COP?
That is part of the engineering work that goes into construction operations plan.
So the ability of DEC and DEP to pursue those activities is not, well, let me see if I can rephrase that. Is it your understanding that Duke Wind will pursue those activities regardless of whatever decision this commission makes with respect to DEC and DEP's ability to acquire the lease and pursue those activities?
I believe that's a question that's better answered by Mr. Repko.
I don't know the extent to which, I mean, there are timelines relative to the BOEM process. So I will assume that Duke Energy Wind is proceeding on those timelines.
And because if they do not operate within those BOEM timelines, it is possible that they would lose their rights to the lease. Isn't that correct?
That's possible, but again, as I said, BOEM has the discretion to grant extensions, and they have done so.
But going back to this concept, I understand we clarified that it's subsea cabling and that you all somewhat disagree with the 36% net capacity factor. But at the end of the day, when you factor those in, assuming their numbers were right, which is what I think you did in response to Council for Avangrid's question, those sort of put the projects on par from a cost perspective. Is that correct?
I would say those are two factors that cancel each other out. There are other factors that go into whether the projects would be on par or not.
And one of those additional factors is the difference in lease price. Is that correct? Which is the $155 million paid by Duke Wind versus the approximately $9 million paid by Avangrid. Is that correct?
That would be one of the factors, yes.
And then if I look at, again, at table 3, I believe on page, I believe it's 49 of your testimony. When it relates to the development expenses, I see that your expenses are greater in 2023 and 2024 when you spend the overwhelming majority of the $62 million in development costs. Is it your understanding that those costs relate predominantly to the SAP and the COP?
So the $2 million is for the development of the site assessment plan. The 20 million includes the surveys and the buoys that I mentioned just earlier. And the 40 million includes the assessment work and the start of the engineering work to support the COP.
So all of this work is either related to the SAP or inputs to the COP?
That is correct.
And you are aware, are you not, that Avangrid has submitted an SAP and had it approved by BOEM?
No, I'm not, and that is actually incorrect. Avangrid has submitted a COP for phase 1 of Kitty Hawk, and they also submitted a COP for phase 2. The COP that was submitted for phase 1 shows interconnection into Virginia, and the COP for phase 2 we don't have access to. It's not part of the public record. Both COPs have not yet been accepted by BOEM.
I'm sorry, maybe I said it incorrectly. What I said is they submitted an SAP and it was approved. They've now moved on to the second step with the COP. Is that correct?
That is correct.
Okay. So to the extent that companies were to negotiate any type of agreement with Avangrid, would you agree with me that you would likely be paying for all of those costs that Avangrid has incurred to date, including the purchase of the lease and the development costs that they've incurred to bring the project Kitty Hawk to the place it is today?
I would defer to Mr. Repko, and not having been part of these discussions that occurred just previously. I think Mr. Repko is in a better position to be able to answer that.
That gets into aspects of the confidentiality agreement.
Wonderful. We can defer that to rebuttal as necessary. I think my last question is, and I'm going to put this question to any of you on the panel. Do any of you have any reason, evidence, or basis to believe that Duke Wind will abandon or otherwise not pursue development of the Carolina Long Bay Wind lease if this commission does not approve DEP and DEC's near-term action requests with respect to offshore wind?
I think I heard it. It was.
I can repeat it if you'd like me
Please,
to.
just the first part.
Does any person on this panel have any reason or basis to believe that Duke Wind will abandon or not pursue development of the Carolina Long Bay lease if DEP and DEC's near-term action requests with respect to offshore wind are not approved by this commission?
I do not have direct information or evidence.
Do you have any indirect information or
Oh,
evidence?
no, sorry.
Thank you. Those are all the questions that I had.
All right, public staff.
Thank you. Thank you, commissioners. Thank you, panelists. I'm Will Freeman. I'm an attorney with the public staff here on behalf of the using and consuming public. If I could ask a few questions about new nuclear. And you're aware that the new nuclear is selected in all 6 portfolios that have been run in this matter, right?
Correct.
And let me step back. I said all 6 portfolios. Duke ran 4 portfolios, and then 2 more were run by Duke after consultation with various parties, including public staff, right?
Correct.
And new nuclear was economically selected in all 6 of those portfolios, right?
Correct.
Thank you. Are you aware that Centrist Energy has been approved in Ohio to make halo fuel that would go in new nuclear reactors?
Was not aware of that information, but I do know that they were interested in pursuing it.
I have a publication from the Department of Energy, press briefing. Thank you. If I could hand these out, and I think we have some help coming too. Thank you. So, if you'll take a minute to review the first page of this, U.S. NRC recently approved Centrist Energy's request to make high assay low.
All right, Mr. Freeman, let's mark the document
I
first.
apologize.
That's all right. Well, the document we marked for identification is public staff, long lead time, resources, panel, direct, cross-examination, exhibit 1.
Thank you. If I can direct your attention to the second page of this document, the first paragraph. Can we say that this fuel needed for new nuclear is underway in Ohio, the United States?
That's what the document says.
Do you have any reason to doubt that?
No.
And I believe you said 700 million was allocated under the Inflation Reduction Act to.
That is correct.
Tell me what $700 million was allocated for under the Inflation Reduction Act.
So it was allocated for a number of different factors. I know 500 million of it was for a procurement to buy HALEU to create a reason for the enrichment facilities to pursue it. I can't recite off memory the other 200 million.
Thank you so much. I'd like to ask some questions now about Bad Creek 2.
Yes.
And I was sitting here earlier and you referenced a 2019 study.
Yes, sir.
Correct? in connection with that 2019 study, you didn't seek special cost recovery such as a deferral for that, did you?
No, sir.
And that study that we're talking about was before HB 951 was passed.
It was.
And this is maybe a question for the whole panel, but possibly you. If there was a comparable energy storage system that was less expensive, would Duke abandon Bad Creek 2?
That's very much a hypothetical. Right now, pump storage, we have 50 years worth of experience with pump storage. It's a very mature technology. I think that's quite a stretch to think we could have that much long duration storage in the time frame that we're talking about with this carbon plant.
Well, then can I phrase it the same question as a hypothetical? Hypothetically, if there were comparable long-term storage that was less expensive, would Duke abandon Bad Creek 2?
Chair Mitchell, I believe he's answered it. He took it as a hypothetical and answered the question.
All right, I'm going to overrule. Let him answer it one more time, and then we'll move on to the next.
So again, we don't see the length of duration and capacity and storage in emerging technology today, even in the future. So it's hard for me, difficult for me to speculate that we would pursue something that has the history and the performance that this technology has that we are pursuing.
Thank you. I'd like to talk about offshore wind for a minute. I believe I heard the panel say 8 to 10 years for offshore wind to come online to hit this 2030 goal. Is that a fair characterization?
It is.
And you remember the 6 portfolios we just talked about. Offshore wind is only selected in half of those before 2040. Isn't that right?
That is correct.
So help us understand why $1/3 billion on something that's got a 50-50 chance of not being selected is not least regrets.
I'll talk about that if I may. So we clearly, again, to the models you point out, we do have offshore wind in about half. But I step back and look at it with a different lens. Ms. Bowman talked about the 4 core objectives of the carbon plan. The last one is executability. So if you take a look at even P5 and P6, which are absent of offshore wind, you've got to look at the whole portfolio and take a look at the scale of the remainder of the resources that is needed to preclude offshore wind. So additional gigawatts of solar, battery storage. The P4, P5, P6 scenarios have 25% additional solar than the P1 scenario, 35% more for P6. Twice the batteries. I think it's P6 has twice the onshore wind components that's necessary to preclude offshore wind. So from an executability standpoint, it demonstrates to me the need to develop offshore wind as an option.
Couldn't we just wait a few years and then do it?
It is relative to the timeline. So I would, the development activities really for all 3 of these long lead items have future value. That development work can be refreshed at the appropriate time and utilized. So it is not throwaway expenditures.
You'd agree with me that DEP has never developed offshore wind.
That's correct.
Can't Duke Wind do this development project?
The DEP would develop offshore wind commensurate to the requirements of HB 951.
Wouldn't it be less risky to shift to Duke Wind or some other third party? Sorry, not just Duke Wind. These offshore wind development projects. Less risky for the ratepayers.
Again, our view is that to maintain offshore wind as an option on a time frame and discretion of the commission that they commence now.
Well, offshore wind was never selected in portfolio 3 and only selected after 2040 in portfolios 5 and 6. And if we have the 8 to 10 years that I heard him say, I'm just doing some backward math, right?
Yeah, so you're correct around where offshore wind fits in terms of the portfolio. So this really gets into this evaluation and the value of onshore wind that the modeling team has in their rebuttal testimony. And I would suggest we leave the question for them in the rebuttal.
Okay.
Yeah, they go into detail on it.
Has Duke Energy studied whether wind leases might be less expensive in light of the fact that the moratorium on the southeastern wind portion was lifted by the Inflation Reduction Act?
We have not done a formal study in terms of future values of lease areas.
Would Duke Wind sell to Duke Energy in 5 years?
I don't know, I presume so.
If Duke Energy bought from Duke Wind the 55,000 acres and did this development process you're discussing and turned out that it did not want to move forward with offshore wind, would Duke Wind buy it back from Duke Energy?
That I don't know.
Commissioners, if I could have a moment, I think I'm near the end of my questioning. Is Duke Wind capable of developing offshore wind?
Yes. I mean, we have got personnel that are familiar, have an offshore wind experience. To date, I do know that they have even developed project management models for offshore wind that have been validated against other developers, experienced developers of offshore wind. And then, of course, whatever expertise in the area of engineering, procurement, and construction, it would be acquired.
You said we, but I think you meant them,
I'm
right?
sorry, the affiliate.
Okay. What benefits do the ratepayers get from DEP acquiring the asset now and developing the wind itself rather than some build, own, transfer or future arrangement in the years to come?
I mean, the value of offshore wind earlier for the regulated utilities is for earliest possibility to be selected by the commission as a resource, and then again as an option for risk management.
If you'll bear with me one more moment, commissioners. Would you agree with me that 951 doesn't require Duke to develop assets, but requires Duke to own assets? And I'm excluding the solar and the battery, solar plus storage battery issue.
I believe that's the case.
Thank you. Okay, thank you, panel. I appreciate your time. Thank you, Commission. I appreciate your indulgence. I don't have any more questions.
All right, redirect. Mr. Repko, just to clarify the record, I believe there were some questions about whether
the companies are asking the commission to select these three resources at this time? Do you generally recall those questions over
do.
the course? Mhm. Are the companies asking the commission to select any of these resources, whether it be Bad Creek 2 or SMRs or offshore wind at this time in this proceeding?
No, we are not asking the commission to make decisions on selection of the resources.
Okay, so the ask is to incur the development activities and the expenses thereof, correct?
That's correct.
And then the companies would come back at a later time, whether it be in a future carbon plan with that information for perhaps a future selection?
That is correct.
Just turning to another point, there was some discussion with Ms. Grunman for Walmart regarding developing the offshore wind lease in the affiliate. Do you recall that?
Yes.
And I believe, and again, this could go into a legal issue that you may not know the answer to, but I believe there was discussion on whether the affiliate could get a return on its investment for development. Do you recall that?
Yes.
And are you aware that in the course of an affiliate transfer, that in addition to the affiliate transferring at the lower of cost or market, it can also get a reasonable return?
I was not aware of that.
There's also some discussion from Ms. Grunman regarding whether Duke Energy Renewables Wind would abandon its development activities of the Carolina Long Bay lease. Do you recall that?
I do.
And I believe you said that you had no knowledge of whether they would or they would not.
That's correct.
Would you just clarify for this commission, why are the companies requesting that the activities related to transferring the affiliates lease to the companies are appropriate at this time?
Yes. Again, when with House Bill 951 requirements for the carbon plan, we sought out senior leadership directed that we pursue all options for a lease. And we pursued those to the fullest extent. That's all I can say at that point. Out of that, with that work, there was a decision in order to maintain offshore wind as an option for the carbon plan that we participate in the BOEM auction for the Carolina Long Bay parcel. And again, our commercial affiliate entered into that auction process, acquired it at the lower of the two parcel prices of that auction, the lower at market value, as demonstrated to a third-party lease. So it was acquired for the sole purpose to maintain offshore wind as an option for this commission relative to a carbon plan resource.
And is there a reason why the companies didn't procure the lease in either DEP or DEC?
It really came down to, number one, to ensure that an option was maintained. Number two, that we could be transferred through an affiliate transfer. And then, quite frankly, number three, we had, as I said, we had experienced personnel with offshore wind that were very familiar with the BOEM auction process.
And isn't it also true that the companies did not want to get in front of ahead of the commission's decision in this proceeding?
Your Honor, I'm going to object. I think this is meant to respond to the subject of direct exam, and I believe the link was to the questions that I asked previously, which had nothing to do with Duke or internal decisions among its regulated and unregulated affiliates and parents as to who should own the lease and bid the lease. So I feel like we've moved beyond the scope of direct exam in council's questions on redirect.
I was just exploring the next question, which is why the companies did not procure the lease in their own names. If it's not relevant to the commission, I can move on.
I'm going to overrule the objection. You can ask the question.
That is correct. We did not want to create a presumption for offshore wind. It is the commission's discretion to select the resources. So we did not want to get in front of the commission.
Thank you. No further redirect.
All right, let's see if there are questions from commissioners. Commissioner Claufelter.
Mr. Nolan, just one or two questions for you. I don't think it'll turn into anything more than that. The company, Duke Carolina, still owns and controls the Lee nuclear site. Am I correct?
That is correct. We have a combined license and we maintain it current.
Okay. Is there, is the Lee nuclear site an eligible potential candidate for an early site permit?
It is an eligible candidate for siting.
Would consideration of that as a potential ESP site in any way impair or interfere with the COL that you're still holding for that site?
The COL is for a specific technology.
Right.
And we know a lot about the Lease site from an environmental and regulatory perspective. And one could argue that you may not need an ESP to build at that site. That's why I gave you the answer.
Say more about what you just said. One could argue that you don't need an ESP?
So an ESP is to mitigate risks associated with siting.
Risk to the company.
Risks to the customers.
And to the
the
customers.
company, yes. And we've already been through an environmental review with Lee. So we know a lot about the site, so we have some degree of confidence in the site. If you select a different technology, then you have affected that combined license.
How have you, if you had sufficient physical land area to put one or two SMR buildings on there, would that impair your COL?
So it would not. But thank you for clarifying. I'm answering under the presumption of knowledge of the site, which is it was designed and selected for a large light water reactor. That land that you're talking about is not readily available, so it's not on the site specifically. We would have to expand the site.
You would have to expand the site.
That's correct.
Okay. And would, if you had to expand the site, would that require you to go through an ESP?
Yes.
Okay.
If it was in a different location.
Thank you for that. Mr. Pompey, I'm going to ask you a question because you're the technology guy and because I don't have anybody else so far that can talk to me about this subject, which is onshore wind, since you were talking a lot about offshore wind. And I really just have an open-ended question for you to get some education. Are you aware of any developing technologies that may be on the horizon or just over the horizon that you're following that might enhance the siting of viable onshore wind in North Carolina, that might expand the area where we could get viable and commercially sustainable onshore wind?
So I'll try my best to answer the question. In my role, I typically focus on emerging technologies. Onshore wind is considered a mature technology. I am not aware of any potential technologies that are on the horizon that would expand the siting as it applies in the Carolinas. I'm aware of emerging technologies for onshore wind, such as high hub height wind, which allows you to place the wind turbines taller to get a better wind profile, but that doesn't necessarily change the siting limitations that we have in the Carolinas, as I understand it.
It wouldn't expand the geographical area where we could get a commercially viable turbine up?
The way I understand it, no, and I might defer to the modeling panel to answer more.
Yeah, we actually, there's a map, I believe, in the appendix. So, you know, the wind resources in North Carolina, coastal or mountains.
Right.
Right, and not much in between.
Right, and again.
And even as far as expansion of the turbines and
Right.
the size, it would still predominantly be in those areas because the difference in the wind resource compared to the middle of the state is that large.
So we're not waiting on any sort of technological development that might grow that map?
No.
All right. Back to you, Mr. Pompey. You had a dialogue with Mr. Smith about the issues that would have to be addressed to bring an undersea cable from the Kitty Hawk site to the injection point at Newbern. And you were talking with him about issues of having to cross Pamlico Sound and come up the Neuse River to the injection point. And so I looked at my maps again, and I'm wondering, prompt this question, what's the proposed landing point for the undersea cable coming from the Carolina Bay site?
We haven't got to the point yet where we could determine where the landing points are, but there are a number of landing points along the coast from as far south as Wilmington to about north near Emerald Isle.
You haven't determined a preferred landing point?
Not yet.
Well, if you come ashore in Brunswick County, you've got quite a long onshore transmission line going up to New Bern, right?
That's correct. We've looked at limitations with different landing points, specifically, the quickest path to get to the interconnection point, New Bern, as well as, the buildability, right? Executability of building in certain population centers.
If you come ashore at Emerald Isle, you have to cross the core sound to get the mainland.
Yes.
So would it be fair then for me to sort of step back for a minute and say, we really don't know which of the two locations, Carolina Bay or Kitty Hawk, is going to be the most expensive or complicated to bring the cable ashore? We don't know that.
The work that we did looked at potential landing points along the coast, as I mentioned, and we looked at it in a location or wind energy area agnostic way. So anything that we looked at in terms of viability and executability would apply to both leases. As a matter of fact, when we looked at the undersea cable length for Carolina Long Bay, the locations that we identified were not the shortest path to get there, because we believe that the early work that needs to be done from a transmission perspective at the time was not wind energy area specific. So any work that we had done and from a feasibility perspective is transferable to both at this time.
That's a helpful answer, and I appreciate it. When you were trying to compare those options for the Carolina Bay site to the potential to bring wind from the Kitty Hawk site to New Bern, were you costing those out?
That's correct. And if you look at Avangrid's limited comments, they actually have a figure there that shows potential landing points, and they show the cabling that we believe is most feasible landing on the north side of Emerald Isle. And, when we looked at it, we pretty much determined, looking at something that could support both wind energy areas, what would the cable length be? And that's how we arrived at the numbers that we did, where we can say that Kitty Hawk is roughly double the length of Carolina Long Bay.
You were looking at a potential landing point on Emerald Isle.
Yes, the same landing point that Avangrid showed in their testimony.
Okay, and that would not cross the Pamlico Sound or come up the Neuse River.
That's correct. That would go, not be subject to those environmental concerns.
Okay, thank you. That helps me understand what I've got. Appreciate it. I'm going to ask you a question or two about a figure J5, which is in Appendix J of the carbon plan on page 8. Do you have access to that?
I do.
Okay. It's figure J5, which is the sample. It's a sample development timeline for bringing offshore wind from Carolina Long Bay. First, I just want to be sure I understand the chart correctly. You've got a series of years there, and you've got arrows running 2 years and arrows running away from years. What are you using there? Is that a beginning of year convention or an end of year convention? If the arrow goes to 2025, is that the end of 2025 or the beginning?
We're using beginning.
So when I look at the very end and I've got my blue star at 2032, that's January 1, 2032.
That's correct.
Okay. So for portfolio 1, you would then be hoping in execution to be able to advance that Blue Star by 1 year, back to 20, well, back to 2031,
So
the end of 2030.
there are two different dates, and I apologize if this gets confusing. Please let me know and I'll help to clarify.
I'm trying to avoid being confused, so you're going
Okay.
to help me out.
So for the purposes of modeling, we had to select a resource that's available at the beginning of the year in order to be selected. So in the carbon plan, the 2030 is January 1st, 2030. In my testimony, when I talk about Carolina's Long Bay being available in 2030, we're talking about end of year 2030. Additionally, the timeline in J5 represents the most conservative timeline in terms of the maximum amount of time that BOEM allows to develop the different products. So 1 year for a site assessment plan, up to 5 years for a construction and operations plan. But in reality, you can get to a construction and operations plan in 3 years. That's why we say we believe Carolina's Long Bay could be in operation by the end of year 2030. Again, accelerating that timeline has risks. So that's kind of where, you can see the timeline can collapse, is really because the time to get from lease auction to COP can be 3 to 5 years. In J5, we selected the 5 years to show the most conservative path.
Well, you anticipated my question and answered it exactly. I was going to really ask you where are the best opportunities you've got to squeeze this timeline and shorten it? And so you've identified construction operations plan. Are there any other places where you think if you're really running flat out, you can squeeze your best chances for squeezing the time?
I do believe that as the market matures, even if we're talking about a 2030 operations date, we wouldn't be into construction until 2027 to 2028. So I think the market could mature at that time, but again, it's hard for me to say with certainty, but that's a possibility, though not as certain.
Right. If you were wanting to deliver power to the grid by the end of 2030 from Carolina Bay and have it on the grid by the end of 2030, when would you need to have finalized your selection of the equipment configuration, your towers, your blades, your turbine? When would you need to have that finalized?
We would look to have because the engineering would have to be mostly complete by the time we submitted a COP, we would look at having that done. But I would say, going back to your previous question, although not an opportunity, but it does highlight, what we're asking for here, right? If we're trying to get something and we want to get it in a time frame that is closer to 2030, it's critical that we, get the work started and accelerated to continue the development. But I would say that by 2027 or so, we would want to have selected, or earlier, we'd want to have selected the technology.
Thank you. That answers the question, and it sort of leads me to the next question: is Duke currently following the new technology that's being developed in Norway for the spindle turbines?
I'm familiar with those generally. I've looked at them. I think one of the areas, in my role that I look at is the technology development timeline. Current axial offshore wind is a pretty mature technology. It's nascent in the US, but it's mature globally. Tens of gigawatts installed, over 20 years of operating history. So, the developers know how to build these things. The operators know how to operate them. So it makes more sense for us to focus on technology that we know is executable as we continue to follow developing technology.
Your first venture into the field, you want to use the existing technology, and maybe for subsequent blocks, you might look at the newer technologies coming online.
Right.
Is
Once
that
it
fair?
becomes available, has gotten to a level of maturity.
Okay. Thank you. Those are very helpful answers. I do have another nuclear question, Mr. Nolan. You were asked a question about public staff cross-examination exhibit number 1. Do you have that there in front of you?
Is it related to Centrus?
Yeah,
Yes.
it is. I want to ask you a slightly different version of the question that you were asked. I think the question you were asked was, were you aware that Centrus had gotten a license for HALO production? And you said you were not aware of that. I have a slightly different question for you. Were you aware that Centrus got a license for a demonstration project for HALO production?
So I'm aware that Centrist is primary business is in Richmond. They have the American Centrifuge plant. They are part of the Natrium project, and they've been actively involved in discussions to develop HALO.
Do you know whether the demonstration project that they were licensed to do for HALO has been continued after June of this year? Is that project still going on, or did it terminate?
I don't know.
Okay. Thank you. That's all.
Commissioner Duffley.
So, good afternoon, gentlemen. My first question is a follow-up on Commissioner Klopfelter's questions regarding the timeline and to achieve the year-end 2030 commercial operation date. At the end of page 50, as well as the middle of page 53. I just want to make sure I'm understanding testimony. So as I understand it, the company is saying that there would be significant increased financial risk to complete it by the end of 2030 because of the fact that equipment procurements would most likely have to be initiated prior to getting the final COP. Is that an accurate characterization?
Yes, that's accurate.
And are there other increased financial risks besides the equipment procurements?
I think that, equipment procurements represent the bulk of the capital expenditures. I think there are certain development expenditures that would probably be increased due to the development timeline acceleration, but in relation, the procurement and the CapEx would be orders of magnitude.
Thank you. And then on page 53, about middle of the page, a little higher, it says projects may be completed in a shorter time period. However, this comes with increased risk and the need to perform development work as early as possible and therefore requires regulatory certainty to proceed. Can you further explain what you mean by regulatory certainty?
Yeah, I think one of the areas in my mind we're talking about, of course, the early development work that we're talking about here for long lead time. And then I think about the Virginia CVAL project. Once they got the Virginia Clean Economy Act, Dominion was able to accelerate that project and get to a point where, they'll be operational by 2026.
Okay, and if we could discuss the costs, these development costs that you're seeking in this case, a pre-approval of, I would say. What account, FERC account, are those costs charged to?
I'm not sure.
Who would be the appropriate witness? Ms. Bateman?
I would believe so, yes.
Okay, thank you. Then you had an exchange with Mr. Smith about the cost delta between the Kitty Hawk lease and the Carolina Long Bay lease. And I just want to make sure I understood your testimony. I heard that there was maybe a math error, and so instead of it being 150 million, it was 350 million. And then I also heard you discuss because of the longer, the undersea line, that was kind of 350 million roughly in additional costs. So I guess my question is, in that testimony, are you saying that with those two issues that they're roughly the same amount, or is there still a delta of 350 million?
Okay, yeah, and I apologize for the confusion. So the error in math that I was talking about was 850 million, not 150. So Avangrid stated in their testimony that a project in Carolina Long Bay would have to be constructed for $850 million less to make up for the net capacity factor difference. But based on their numbers, that capital expenditure is actually 350 million. So I think that was an inadvertent error on their part, but I wanted to correct it. The 350 million less, if you assume the premises, would then be offset by, roughly, I want to say 100 miles or so of additional cabling. That comes out to, around 350 million. So I was trying to illustrate that those two are offset, but also that there are, multiple factors that affect whether one lease area is, what I would say better than another, because it's not a simple question of, one has a better wind, so it's a better lease area.
Okay, thank you for that. And then turning to page 32. And this is in the nuclear section. So with there was some questions about the actual spend in 2022, and you stated that the actual spend was $1 million, not $5 million.
That is correct.
So what about the 3.5 million?
Oh, it's inclusive.
It's inclusive. So that 1 million is not just for the top, it's for the full 850 or 8.5 million. Okay. Okay. Those are my questions, gentlemen. Thank you.
Commissioner Hughes.
Yeah, I realize that we're all trying to figure out what the IRA does to everything. But I am intrigued by the calculus that you were doing where you were lumping transmission and development costs together and kind of doing the comparison, because the way I understand it is the IRA was a big boom for the actual development cost, but left transmission alone. So have you redone that analysis, or is that changing the whole way we should be thinking about kind of where you cite wind and kind of trade-off between what, and I'm still learning, is there any insight on where the development costs of these wind projects actually stop? Like which part of the transmission can come for that really generous tax break and which can't?
Yeah, so thank you for that question, because it is a little bit confusing. For offshore wind project, part of the project cost includes the wind turbines, the substation, the offshore substation, and all the cabling until you get to the point of interconnection. So that includes the subsea cabling, plus the onshore from whatever landing site we select, and the pathway to get to New Bern. Once you get to New Bern, end of project. From New Bern, any upgrades at New Bern, going into Womack to Wake, wherever the load center is, that's part of transmission.
So we have to keep rethinking about what transmission means for.
Right.
Okay.
And, and the other, sorry for interrupting, the other question you asked about, I think the IIJA had provisions for loan guarantees for transmission. The IRA has production tax credits for wind. So we haven't, gotten to the point, or, the Treasury hasn't gotten to full rulemaking, but the way we understand it is some of the investment tax credits that were set to run out are now expanded through the 2030s.
Okay, thank you.
Commissioner McKissick.
Well, actually, I think virtually every question I had in the back of my mind has been clarified either by, I know Commissioner Clodfelter asked one or two, and the rest by interveners, so
Okay,
no
perfect.
questions at this time.
Commissioner Kimwright?
I just have one question that follows up on questions from Commissioner Clodfelter and Commissioner Duffley, and then also the public staff's questions, and it's about offshore wind. And in your testimony on page 45, you talk about, excuse me, I go back to the page, excuse me, page 43, talking about it takes about 8 to 10 years from the time of securing a lease to reaching commercial operation for offshore wind. But then I believe you clarified that that timeframe might be able to be accelerated in response to Commissioner Clodfelter's question. And public staff's question had been, the way that I wrote it down was, can't we wait just a few years to make a decision about securing the lease? And so I think that what I'd like to ask a question about is maybe not a response was that you want to be able to maintain offshore wind as an option. So can we wait 2 years until 2024? Or I'd like to hear the response about that, about securing the lease, because when you look at the table 3 on page 49, the lease cost is the greatest of the procurement cost, the near-term development costs. So I guess my specific question is, for a 2-year period of delay, would we still be able to maintain the option for offshore wind?
So when we talked about, moving the schedule, getting a shorter schedule, we were talking about the 8 years is the shorter schedule. That's the one that we think has executability risk. The 10 years has less executability risk. If we wait 2 years to come back and in 2024, the decision is that we need to get offshore wind by 2030, we will have lost 2 years, and then that opportunity is gone. If we decide we want offshore wind by 2032 in some of the portfolios, then we would have lost 2 years and would have to incur additional risk to try to do a 10-year project in 8 years because we had not been expeditious with the prior 2 years.
Thank you.
You're welcome.
Okay, just a question or two for you. Following up on the conversation you had with Commissioner Clodfelter about the Lee nuclear site, I'm just curious, and I'm hoping you all can help me understand siting new nuclear generating facilities at existing sites, be they the Lee site, which is undeveloped to a certain extent, or other sites that the company owns on which nuclear is operated. Help me understand, is that a possibility? Is that something you all have explored, or is it, can you speak to that?
I can.
Okay.
So we are looking at siting in North and South Carolina. We're starting by looking at water availability, transmission access, land availability, seismic, and population exclusion zones. So one of the challenges with the existing sites is that sometimes populations grow up around them, and then that becomes less advantageous. Some of the advanced reactors are more suitable, and the NRC is revisiting its guidance on population exclusion areas. So we are following that. I don't know if you saw in the news, but that the Dow Chemical is looking at siting an advanced reactor in what would be normally a more populated area. So we are continuing to look at all of those. Some of our sites are candidate sites, and we are looking at retired coal facilities as well. They weren't available when we were looking at doing the siting for Lee. So I think we're taking a broad look and looking at the various aspects to screen them down into a small candidate list.
Okay, so just to make sure I understand, so the SMR, is your testimony that the the advanced nuclear reactors are more suitable for denser areas than the SMR?
Correct.
Okay. Okay, well, but you all will continue to look for every opportunity to utilize locations that you already have or efficiently develop these new technologies where it's feasible to do so.
That is correct.
Okay, let's see, I think that's all for now. Let me just check in. Any additional? Okay. Questions on commissioners' questions? We'll start over here. Let's go, we'll go in Sigfer and, but actually, Avangrid, do you have questions?
None at this time, Your
Okay.
Chair.
Okay.
No questions from CC.
Okay. Go ahead.
Thank you, Chair Mitchell. Just one. The panel was testifying, I believe it was in response to a question by Commissioner Clodfelter about compressing the timeline and what risks would be associated with trying to expedite the timeline. And I believe the testimony was that there would be procurement risks and financial risks. Is that correct?
That is correct.
Make it two questions. Would there be any other consequences from trying to compress the timeframe, specifically with respect to increasing total project costs or potential associated rate impacts?
Yes, so I did mention that there would be costs associated with accelerated development. So there would be development expenditures that would go up, and as I mentioned, the largest portion of the costs would be associated with CapEx. And those would be at risk, but not necessarily inflated due to the accelerated timeline.
Thank you.
I want to follow up on some questions from Commissioners Kemmerat and Clodfelter. I'll start with the question you received last. And Mr. Pompey, I think your response to Commissioner Kemmerat's question about could we wait 2 years was that we would have lost 2 years. Is that fair?
Yes.
I guess I'm a little confused by that response because I thought that in response to some questions that I asked on my direct exam, that it was my impression that development activities were going to be ongoing, even if they were being conducted by Duke Wind over the course of the next several years.
So the question was around, the way I understood the question was around, the 8 years versus 10 years. I can't speak to the work that is happening, at Duke Wind. When we put the near-term activities together, those were our estimates based on what we would do as a regulated utility. I don't know what work would happen with Duke Wind in the next 2 years, and that's specifically why we're asking for that, is because why we're asking for approval to incur these costs is because the commission would have maximum optionality as well as direction to direct the regulated utility in what direction they wanted us to go.
But you agree with me, do you not, that in looking at J5, which is on page 8 of Appendix J, that if we look at the timeline as it presently exists, that in the near term, by 2023, so let's say May 2023, the plan would be to submit the SAP to BOEM. And my understanding from your direct testimony is that that process is underway at Duke Wind at this time. Is that correct?
It is my understanding that it is.
And then during that time frame, you're waiting on approval from BOEM for the SAP, which by your table at J5 occurs in or around 2024.
So as I mentioned, the BOEM allows a maximum of 5 years to submit a construction operations plan. It doesn't take necessarily 5 years to do that. So for example, Duke Wind, as a hypothetical, could submit a SAP as required by BOEM within 1 year of acquiring the lease, and then would not necessarily be obligated to do COP work in order to meet the 5-year timeline. So we come back in 2024, and what I meant by losing time is we would have lost the time to have done the engineering work associated with submitting a COP. taking away the opportunity to submit a COP inside of 5 years as a hypothetical.
Okay, but so one of the other things that the commission could order the companies to do, and this is in part a follow-up to Commissioner Clodfelter's question, where he asked you whether we don't really know whether Kitty Hawk or Carolina Long Bay are the cheapest, right? One of the things the commission could order the companies to do or appoint a third party to do is to study these two projects and to develop more detailed cost estimates of these two projects, and to be able to come before the commission in 2024 with more information about which one may or may not be cheapest, more feasible, more appropriate for the commission to select as a resource as part of the carbon plan. Isn't that fair?
Chair
Yes, Ms.
Mitchell, I would just say that the first line of questions were legitimate based on commission questions, but now we're going into something she could have asked him on cross.
Commissioner Clodfelter's question was, we don't know whether Kitty Hawk or Carolina Long Bay is the cheapest, do we? I wrote it down verbatim. I'm following up on that very specific commissioner question to seek clarity on what that means and how the company responds to that very direct commissioner question.
All right. I'm going to overrule the objection, but I'm going to ask you to state more succinctly your question, because it was compound and I lost it. So just please simplify the question, ask the witness so that he can answer, and we can move on.
I'll do that. I apologize. It's late in the day, so I may be asking long questions. Commissioner Clodfelter, you recall when he asked whether we don't know right now whether Kitty Hawk or Carolina Long Bay is the cheapest. Do you recall that question?
I do.
For purposes of the 2024 carbon plan, the company or a third party could study the Kitty Hawk lease and the Carolina Long Bay lease and present to the commission more detailed information about the differences between those two parcels to decide which one is in the best interest of ratepayers. Is that correct?
Mrs. Grunman, I believe you're agreeing with my testimony here. That's why we think it's important to do the site assessment plan and start the development work so that we can have the information to say some of the questions such as net capacity factor, wind turbine placement. All of these questions would be hypothetical and not reliable without the early work that goes into classifying the site. If we do that, then we have more optionality to be able to make an informed decision in 2024.
But the commission could order that analysis work be done without the transfer of the lease to Duke Energy Progress, could it not?
I would defer that question to Mr. Repko.
I'm hearing you're questioning if the commission can direct the affiliate to do the analysis work?
No, if it could direct you to do the analysis work. And would you not be in a position where you could request information from the affiliate about the net capacity factor? Is it absolutely necessary for you to, well, let me back up. We've indicated, have we not, and I understand we can't talk about the specifics, but that there's an agreement in place with Avangrid, is there not?
Correct.
And without getting into the specifics of that, there's already some sort of a contractual arrangement that creates some rights among the parties. You could enter similarly into some sort of an NDA with Duke Wind that would allow you to share information with them as well, would it not?
Chair Mitchell, I think we're now getting way far afield and probably outside the scope of the expertise of this panel, since we're probably wading into other affiliate agreements as well as code of conduct issues.
All right, I'll sustain it, but I'll allow you to ask the question a different way, simplify it, ask the question so he can answer it.
Is it your position that the only way for Duke Energy Progress to be able to study the cost differences between the Kitty Hawk and Carolina Long Bay parcels is for Duke Energy Progress to own the Carolina Long Bay parcel?
That's our position, that it's the most efficient, and I'm not aware of other potential arrangements.
Since I think any follow-up questions would involve confidential information, I'll defer those questions until the rebuttal testimony. Those are all the questions that I have. Go ahead.
Panelists, thank you for your attention again. Have we considered citing the new nuclear at some of these coal plants that are either retired or being retired?
Yes.
Did I understand, in following up on the question about what would happen if we push this off for 2 years? Did I understand, Mr. Pompey, your testimony earlier was that unless you take certain steps, Duke Wind must take certain steps, or else the Bowen people can say, you're resting on your laurels, we're going to lapse the lease. Is that a risk if they don't move forward with certain actions?
It is, in so much as the maximum allowable time. And Mr. Repko testified earlier that, BOEM has made exceptions to the timelines in the past. And my testimony was that, the SAP has a 1 year and the COP has a 5 year. So, in between there, you've got some time, whether you choose to accelerate or not.
So I know Duke Wind isn't here today, but we can make an educated guess that Duke Wind's gonna not want to lose its $155 million lease, and we'll move forward with the SAP at least, right?
I think that's a fair assessment.
Thank you. I don't have any more questions. Thank you.
I have no redirect.
Questions on commission's questions? No questions on commission's questions? Just being clear.
I apologize. I
Okay.
have questions on commission
Okay,
questions.
just being clear. All right. Okay, with that, I'll entertain motions. You all may step down. Thank you for your testimony today. You are done for today. Council, anybody need to move documents into the record?
Chair Mitchell, we don't have any exhibits to the testimony.
Chair Mitchell, at this time, Sigford 2 and 3 would move its long lead time panel direct cross-examination exhibits 1 and 2 be entered into the record.
All right, hearing no objection, motion's allowed.
Thank you.
Chair Mitchell, at this time, CPSA would move that CPSA Duke Long lead time resource panel direct cross exhibit 1 be moved into the record.
Motion's allowed.
Chair, the public staff would move its exhibit long lead time resource panel direct cross-examination exhibit 1, which was Centrus becomes first U.S. licensed HALEU production facility, into evidence.
All right, motion's allowed. All right, at this point in time, what I'd like for you all to do is recall Mr. Roberts and Ms. Farber to come up and take questions from the commissioners. I'm hoping that we can get through that, questions from the commissioners and questions on commissioners' questions today.
Thank you, Chair Mitchell. Glad to do that. Give us a couple seconds here to get organized.
All right, let's go ahead and get started with questions from commissioners. Just a reminder, y'all are still under oath. Commissioner Clodfelter, why don't you start?
As far as one question for you, I don't remember whether you were here for the testimony by the modeling panel. I'm not sure you were.
I've heard a fair portion of it.
You heard a fair portion of it. I asked the modeling panel to respond to the suggestion that had been made by one of the consultants for one of the interveners. And again, I'm not sure I remember exactly which one it was, but the suggestion was that
Duke should consider testing the waters with a 2023 RFP for onshore wind, just to see what you got back and how ready people were maybe to proceed with that. And that question was referred to you. So I put the question to you. Will you want to comment on that suggestion?
Sure, I'm happy to. So we are excited about the opportunity for onshore wind, but recognize that there are challenges, particularly with siting of onshore wind. So we are working on ramping up internal preparations and capabilities for self-development, but also starting informal conversations with the onshore wind development community. Obviously, it's very nascent in North Carolina, and so we're trying to get more information, take the temperature. Is there a pipeline of projects that would even be interested in a 2023 RFP opportunity for acquisition? So we haven't had, formal stakeholder meetings on the topic yet, but that's sort of where we're headed. We want more information from the market to see if there is even a pipeline that would be prepared as early as 2023 for an RFP. It might just take longer.
You don't have enough market intelligence now to be able to even think that the expense of an RFP would be worthwhile.
Not yet.
Okay, that's a fair answer. Let me stay with onshore wind for just a minute, but shift over to you, Mr. Roberts. I feel like I can see the red zone map in my dreams now. And every time I call it up in my head, I see that Carteret County and Hyde County are not in the red zone. And then I look at the NREL map on wind potential in North Carolina, and well, lo and behold, there they are. So that's where it is. Carteret and well, we're not going to talk about the Ridge Law. I'm not going to talk about the Ridge Law, but the wind potentials in Carteret and Hyde counties. Is there any transmission constraints that I need to worry about in connection with those locations?
Yes. I think when you start looking at the aggregate resources that could influence the power flows coming in that area, i.e. solar, offshore wind, and onshore wind, there will be some transmission constraints that need resolving.
Are you able to identify what those might be? I mean, you've got a 230 kV line running from Havelock down east through Carteret County. Is that going to be the likely point of interconnection for most onshore wind?
For onshore wind, if it's located in Carteret County, yes. It would probably be utilizing that 230 kV line.
Are you aware of whether that's a constrained line now? What is it operating close to thermal load capacity?
Right. To my understanding, it's not a constrained line currently.
Do you know how much headroom there is?
I do not.
Don't know.
Yeah. And I mean, with the interconnection studies that we perform that are in a TPL 001 like manner, you look at a loss of generator. So that would probably be Harris that would carry more of that load to the west, or more of that power to the west. And then you would look at loss of a worst case line. So loss of a worst case line would probably be that Havelock Moorhead line, unless you did a parallel line or upgraded to 115 line.
That's fair. Oh, let me, I don't know if you still have the exhibits from when your panel was up. So I'm looking at public staff transmission panel across exhibit 3. Is that one still around up there, floating around anywhere?
I don't have numbers. What's the title?
Yeah.
Perhaps your counsel can help you.
The documents, we just don't know which one's which. I think it's one.
It's the 2022 NCTPC study scope document.
Yes.
Okay. And you were asked some questions about the document. One of the things that I wanted to ask you about is on page 6. So the scope of study here will model the system, assuming the retirement by the summer peak of 2027 of a number of CT units at Darlington and Blewett and Weatherspoon. It looks to be the total is just right at 750 megawatts of CTs. Those are essentially being retired because they're at the end of economic life. Is that correct?
So, subject to check, I believe Darlington County 1, 2, 3, 4, 6, 7, 8, and 10 are already retired.
Already
Yeah,
retired?
so it'll just be captured in this study. And Blewett CTs 1 through 4 and Weatherspoon CTs 1 through 4 are not retired. So that would be new.
Those would be new retirements.
That's correct.
Well, let me tell you where I want to explore what you can tell me about is because, I mean, Darlington, Blewett, and Weatherspoon sit right in the center of the red zone. And I was wondering whether or not, when you've done the supplemental studies and the other work you've done on the red zone, whether you were taking these retirements into account already, or whether these retirements might create some additional transmission headroom.
Right. So if these retirements are in an approved carbon plan, then we will take those into consideration for the projected timing associated with the retirements. The Darlington units, my understanding is that generation has already been retracted from prior models, taken out of prior models, and thus that space has already been used up.
So your red zone identification of the 18 projects in the red zone already assumed the Darlington retirements.
That's
Did your analysis assume the Blewett and Weatherspoon retirements?
Subject to check. If it was an approved IRP, 2020 IRP,
Right.
then yes, it would have considered that. That's subject to check.
Okay, that's good. I can look at the IRP later. Thank you. Is there, this is for my general education, but it also goes to some of the issues we're talking about. So is there a sister or a brother organization to the NCTPC in South Carolina to do local transmission planning in South Carolina?
They don't perform the same functions, but the CTCA, the Carolinas Transmission Collaborative Agreement or Association, I can't remember what the A stands for. CTCA.
CTCA?
That's correct.
It performs the same function as the local transmission planner?
Somewhat similar. They just primarily do reliability studies.
Do they do any public policy studies?
I have not heard from the transmission planners that participate in that group that they've done public policy request studies.
Who are the participants in the CTCA?
So it's DEP, DEC, South Carolina Public Service Authority, Sandy Cooper, and Dominion Energy, South Carolina.
Okay. Organized very similar to the North Carolina Collaborative? Similar decision-making process?
I'm not sure what their organizational structure or decision-making process is.
Okay. Well, let me tell you what I want to ask you about there is I don't recall, but I think there's either 4 or 5 of the 18 red zone projects that are in South Carolina. I only know that by looking at the names of the projects and knowing where those places are. How many, can you correct me on the exact number? How many of the 18 are in South Carolina?
I'll have to look at the map. Sorry.
Okay.
I know the 4 in DEC are in South Carolina.
All 4?
Yes. And then I believe a portion of the Robinson Rockingham 115 is in South Carolina, and then or 230, just 230. And then the Weatherspoon Marion.
That would be a South Carolina, between the Weatherspoon plant and Marion.
Yeah, of course, the Weatherspoon end is in
Right.
North Carolina. But
Right.
I believe the Marion end would be impacting South Carolina.
Do you know whether those projects have been reviewed by the CTCA and put into any transmission plans in South Carolina?
No, I don't believe they've been included in CTCA's reliability study.
Is there any plan to submit them for reliability study in South Carolina?
Not to my knowledge.
Is there some other approval process that those transmission projects in South Carolina need to go through in order to get you into a position where you can start construction?
If
right-of-way acquisition and
Yeah,
construction?
my understanding, so these are just true upgrades to existing lines. However, with Robinson Rockingham being a 230 line, I believe there's a stipulation in the South Carolina statutes that a CPCN would be required, even though it's just an upgrade.
what happens if you don't secure the necessary approvals for those South Carolina lines?
Right, so we would continue to pursue that approval to try to persuade the South Carolina Public Service Commission of the need for that upgrade in order to locate more solar, even in, South Carolina and the high solar viability areas, upper PD area.
Are those projects in your most recent South Carolina IRP?
So there is quite a bit of solar in the South Carolina IRP.
What about the transmission projects that are in the red zone?
No, that wasn't included in the modified IRP that was submitted in 2021.
Okay. I want to ask you a question about your testimony on page 39. And I'll tell you where the question's going is, I'm just not sure I understand it. So I'm looking really for basic understanding here. Starting on line 15, you have a sentence that says the commission's acknowledgement of the need for the RZEP projects to interconnect new solar generation and meet the objectives of the carbon plan will provide strong evidence to the NCTPC that approval of the projects in the 2022 transmission plan is a reasonable and prudent step. And then this is where I got lost. It then says, in the alternative, based on the results of the supplemental studies, the commission should acknowledge the need for the 15 RZEP projects identified in those studies. What's the choice I'm being made, have to make there in the alternative?
So the original red zone expansion plan consisted of 18 projects. Yes. And so the time this direct testimony was written, we were requesting acknowledgement that all 18 were needed. But, based on other studies, the supplemental studies, where it showed that the Irwin Mill Burney 230, the Sutton Wallace 230, and the Rockingham West End 230 West line upgrades were not needed or didn't show up at that point in time in those supplemental studies. Based on those three lines showing up, the alternative would be to acknowledge those remaining 15 are needed.
So that's the alternative is either endorse 18 or endorse the 15.
That's correct.
Thank you. I just wasn't sure how I should be reading that. I want to ask you some questions about the discussion of the potential transmission upgrades related to the retirement of the Marshall coal units. And I think you talk about that on page 53 of your testimony.
Okay.
Tell me again, what is the need, the system need that has to be addressed when you retire those Marshall units? What's the transmission need? What occasions that
Right.
need?
So at certain load levels, you've got McGuire plant, about 20, close to 2,300 megawatts to the south.
Right.
And you've got Marshall plant to the north, and you've got two 230 kV lines in
Right.
between. We call them our Westport lines, or bus to bus. It would be the Marshall McGuire 230 lines. And so at certain load levels, if you don't have enough Marshall generation on, the McGuire generation to the south will influence the power flow on those lines such that if you lose one of the 230 lines, the other one will overload. And that's why the Marshall reliability must run procedure is documented to that effect.
So it's a contingency to keep the load in balance between those 230Ks. Are there any solutions to that other than an upgrade to the two lines?
Yeah, so we have looked at other solutions associated with that, just in concept, not a study. But anyway, such as series reactor, and that's still on the table. So it's not, if that will work for all circumstances, then we could possibly do that. But right now, it's looking like we would have to upgrade the two lines.
Say again what that solution was. Call it again, the name. I
A
didn't hear you.
series reactor.
A what?
Series reactor.
A series reactor.
Yes.
Describe what that piece of equipment does, what it's
It
functions.
just introduces impedance in series to the line, and
Okay.
so it impedes flow on the line.
Is there a solution that involves perhaps operating one of the Marshall units as a synchronous condenser? Could that be a possible solution?
So synchronous condensers are primarily associated with providing dynamic VARs, reactive support. So if it was a voltage issue, a synchronous condenser, that's a good thought if it's a voltage issue to resolve.
But your issue is not a voltage issue
That's correct.
at Marshall.
That's correct.
Okay,
Yeah.
all right. If Marshall were to convert to another fuel source, and I'll ask the modeling panel about that, I'm not asking you about that, but that would not require a transmission upgrade. If you were to convert Marshall 3 and 4 to a higher percentage or to 100% gas firing, you wouldn't have to do those transmission upgrades, would you?
So my understanding is at certain load levels, like in the 18,000 range, subject to check, you would need all 4 units online, and that's to protect against one contingency. If one of the units trips, which is that one contingency, and you lose one of the 230 lines, you still have enough generation to provide pushback.
Okay, so the need is triggered by the retirement of 1 and 2. Even if you're still operating 3 and 4, you're still going to have that need.
That's correct.
Okay. On page 53, I'm staying with Marshall for a minute. Let's see if I can find the sentence here. Mr. Roberts, I obviously have lost the place where the sentence is used. I think it's in the carbon plan itself and not on page 53. I think it's the sentence in the carbon plan that follows the sentence you quoted there on lines 9 through 13. The sentence says something to the effect of these transmission upgrades would also earlier, while Marshall 1 and 2 are still running, permit you to operate them in something other than a must-run fashion.
At those load levels, correct. I mean, usually at those high load levels, if we don't have replacement generation elsewhere that can provide those megawatts, at those load levels, we're going to need those megawatts to serve the customer demand anyway.
And so you might need that even before you retire 1 and 2.
That's correct.
Is that being studied?
With respect to replacement generation?
No, with respect to the upgrades to the McGuire to Marshall 230s, whether you need to bring those online sooner than the retirement dates of Marshall 1 and 2.
Yes, that project has been looked at with respect to timing.
In the collaborative, has it been looked at by the collaborative?
It hasn't been incorporated into the collaborative study yet.
Okay. All right, I think I'm going to leave Marshall alone for now, but I want to move to Roxborough.
Okay.
So as I recall your testimony yesterday, and be sure I got it right, I think the gist of the testimony was that once the Roxborough units are retired, all 4 are retired, that if you didn't have replacement generation at the Roxborough location, interconnecting at the point where the Roxborough 1 through 4 now connect, that you might still have to install a static VAR compensator.
Yeah, there would be a couple of modifications that would need to occur before then. And even then, we would need to conduct a pretty sophisticated or thorough study to determine exactly what upgrades. But right now, we're saying a 300 megabar static VAR compensator would be required, and you would need to install auto load tap changing transformers at our Harris plant.
Okay. Well, that is a VAR issue you're addressing. So
That's correct.
So is that operating 1 or more of the Roxborough units as synchronous condensers? Is that an option to avoid having to do the VAR upgrade?
So that could be an option. The advantage of the static VAR compensator is it would be located closer to where the VARs are needed. If you try to transfer VARs a long way over a transmission system, the transmission system just sucks them up for the power flow. But without that amount of megawatts there at Roxborough trying to move across that transmission system, a static VAR compensator may help. Excuse me, I'm sorry, a synchronous condenser may help.
What's the range of cost of a SVAR compensator, SVC?
A static VAR compensator? for 300 megabars, subject to check, around 50 to $100 million. I'll have to look.
And what would the cost be to operate one of the units at Roxborough as a synchronous condenser?
I don't know that cost.
That is something the company's willing to explore and investigate?
Yes.
Yeah, I mean, the SVC would go into rate base, but Roxborough is close to being fully depreciated. I understand that difference, but I'm not really asking about that.
Right.
All right, well, give me just a second. I think I may have, thank you for your help, by the way. I want to go back and ask you a question on page, well, it's not in your testimony, but you'll know the answer. I think there is, let me just ask the question, then see if you can answer. If not, I'll leave it alone. In the testimony, the modeling panel, there was there are multiple maps of the red zone. They're everywhere. They're all over the place. And there is one map in which the DICES projects are overlain with the red zone map. And I was just curious, as a matter of information, there are two fairly large battery projects in the DICES cluster that are right around Charlotte. What are those projects? Do you know?
So just to give you a page number here, page 35, figure 2, I believe is what
Oh,
you're
it's in
referring to.
yours as well as in theirs. Okay. Like I say, the red zone is everywhere. What are those two projects? Can you tell me more about them?
Is one of them Allen? I'm not sure what those two battery projects are. I would have to look at the DICES cube and
I
see.
tell you what, I can do that or have commission staff do that later. I just thought you might know here today off the top of my head, and I could check that off my worry list. That's fine. That's all I have.
Commissioner Duffy? Okay. Commissioner Hughes?
I have a question, but it might be more appropriate to witness Roberts on the reliability panel. So, and given where we are, yeah, I'm willing to defer to him. But if you, Ms. Farber, if you have a quick answer, I just want understand a little bit about resiliency versus reliability. We've talked a lot about reliability. The modelers talked about reliability. Your testimony is full of reliability, but you also talk about expanding planning and becoming more integrated. Should we be thinking about resiliency? Some of the interveners have brought it up. Do these transmission projects, the portfolios, combinations, if we started looking at them with a resiliency lens, do they look different?
Yeah, absolutely. The cost benefit analysis showed that with respect to replacing these old assets, transmission assets with newer equipment, with replacing wood poles with steel poles, new structures and new conductors, that you would see resiliency improvements. That's kind of how the model looks. The probabilistic model looks at it that way with respect to failure and influencing customer outage. And the other thing if you're thinking about resiliency with respect to restoration for storms, those structures have been shown through hurricanes that we've had to greatly accelerate restoration. And by that, I mean, now you have trees leaning on lines that you take a clearance and you cut off, versus in the past, tree hit a line, the wood structure would break, and then you're replacing, it usually takes down a few spans, and then you're replacing all those spans with new structures.
Okay, again, so it's mainly when you're doing these replacements, but when you're talking about full out combinations or lines you work on, or different parts of the state, locational kind of issues that might have a resiliency impact, distance to load centers, that kind of thing. Should we be talking more about that, or will we be talking more about that in the future as supposedly, as the world gets to be a more dangerous place?
Yeah, I think resiliency and reliability kind of go hand in hand, and yeah, I think we need to keep our focus on that. The House bill requires us to focus on reliability piece. I don't know that the word resiliency is in the House bill, subject to check, but I think that is an important point, that we do need to look at resiliency benefits as well as we're going through this holistic proactive transmission planning process.
Okay, so in the future, we can do that.
Yes.
All right, in the interest of time, that's good.
Okay, Commissioner Duffley.
Commissioner Hughes's question sparked a question in my mind. You mentioned and testified earlier, you stated that there was a net benefit of these large projects based upon a cost-benefit analysis. Where can the commission find the inputs or review that cost-benefit analysis? Is it in the NCTCP or
No,
is it in something you filed in the carbon
Yes,
plan?
it's described in the testimony.
Okay.
The tool that was used, and it's a common industry tool, and it has a reliability component and it has a asset replacement component. We used the asset replacement component in this testimony, and it showed an average CVA of 15 plus. But just
And so the information that I have is within this testimony, just you limited to what, if I wanted to dig down further, where would I go?
so you could review the information in the testimony, and if that's not sufficient, you need more information, you can send a question and we'll answer that.
Okay, thank you.
You're welcome.
Commissioner McKissick. Commissioner Kim Wright.
Mr. Roberts, I have just a couple of questions. First one is you talked about the transition cluster study, and I believe you said that there were only about 180 megawatts left still being studied in the transition cluster. Did I get that number right?
Subject to check, yes.
And do you recall offhand how many megawatts of for projects that initially entered the transition cluster?
That information is actually in the testimony. I'll just have to find the page. Actually, I think it's in Appendix P. I don't think we included it in the testimony.
Transitional cluster study report on page 12.
Page 12. Yeah. Okay. Okay, so for DEP in the transitional cluster study, in DEP in the transitional cluster study, there were 1,445.9 megawatts that dependency on the freeze-in upgrades.
Okay.
I don't see a total number. Oh, okay. 30 projects requesting 1,860 megawatts of interconnection service withdrew after receiving phase 1 transitional cluster study results that showed an average network upgrade cost of around 17 cents per watt.
Thank you. I just have a couple of questions that I think what I'm trying to get some clarification about is allocation of cost and really who pays for transmission upgrades when those upgrades, if they are ultimately included in the NCTPC's local transmission plan. And so for interest of time, I'll tell you what my understanding is, and then please correct me if I'm not correct, so that just to keep it moving along. But currently, these red zone upgrades are not included in the NCTP's local transmission plan. So I think that we all heard a lot of testimony about that, but I think the importance of that is that means that those upgrades are not included in DEP's or DEC's baseline. Is that correct?
That's correct.
Okay. And then if these upgrades are to be included in the NCTPC's transmission plan, they would be these public policy projects that would be, I think, the first time that would be considered upgrades as public policy projects. Is that correct?
That's correct. I mean, you could also state that they're for generation additions as well.
Right. And I think there was also was a little bit of testimony about they potentially could be considered to be reliability projects as well. But if they are included in the local transmission plan, or I should say approved in the local transmission plan, that means that for purposes of later studies like the 2023 DICES cluster study, that they would then be in the baseline. Is my understanding correct?
That's correct.
Okay. And if they're in the baseline, then what I think that means is that during the DICES study, the cost of those upgrades would not be assigned to any of the projects in DICES that otherwise that would have triggered previously those transmission upgrades.
That's correct. I mean, either you go through the process of your interconnection request, studying that, you get to an interconnection agreement, and the resulting upgrades, the customer would pay for upfront. If it's for a project, they get reimbursed.
Right. And then for the solar procurements that we'll be dealing with, if for these projects that would have the red zone upgrades in the baseline, then those transmission cost upgrades would not be assigned to those projects, or I should say would not be included in their bids for solar procurements. Is that a fair way to consider it?
So I'll let Ms. Farmer speak to what a potential 2023 procurement and selection basis would be, if that's been considered.
I don't know that we have all the details worked out, but typically, if the cost of a transmission upgrade is in the baseline and the cost is not assigned to the generator, then that would not be considered part of the evaluation of the cost of that generator. However, for this 2022 RFP, the commission specifically directed us to not include those upgrades. And so the current thinking is that that cost would be included in the evaluation for the 2022 RFP.
Okay. And then just, I guess, one final question that doesn't really deal with solar procurement, but if projects can still interconnect out or enter into interconnection agreements outside of these solar procurements currently. And if a project that was going through DICES is looking to interconnect and enter into an IA, and those red zone upgrades are part of the baseline, then that project would not have to pay for any of the transmission cost upgrades. Is my understanding about that correct as well?
Yes, that's my understanding as well.
Okay. Thank you. I think that was good clarification for the way that I understood it to be worked.
Commissioner McKissick.
Well, just one point of clarification, and this goes back to the testimony that was being provided about bringing in Midwest wind. And the thing I was curious about, apparently back in 2019, there was this study with PKM where they provided the estimates, and it came in about 411 million. Now, as I recall, you said that a request is now in the queue where more information would be provided at some point in the future, where there'd be more clarity about what could be done. But I guess put a marginal note here. So I just want to get some clarification about what that time frame would be, or what you were waiting on in terms of additional information that could be provided at a future date.
Right. So the 300 megawatts in 2019 was associated with a feasibility study.
Mm-hmm.
And once again, just like you said, $411 million, 84 months for upgrades to be completed associated with that request. And that the sync for that feasibility study was Duke Energy Carolinas. The commission directed us to look at the potential for capacity purchase from PJM, specifically for Duke Energy Progress. And so that's what we analyzed in the study. And we just want to get validation associated with that study with respect to the 1,000 megawatt TSR. And it's the results of that TSR will probably be valid with the exception of the network upgrades on the company side. it'll probably be valid for either area.
Be valid for either area?
That's correct.
And when do you anticipate you'd receive some validation or?
So PJM processes TSRs in parallel with the generator interconnection request. And so I'm not sure if their current queue reform will impact the timeline associated with receiving the information from that transmission service request. So I can't give you a definitive time.
Okay. And I'd like to switch gears a little bit. I'm sure you heard the preceding panel. You were here, weren't you, during that time frame? Or maybe you were not.
So as far as the long lead panel?
Yes.
I was trying to recover a little bit.
You were going through some food poisoning. In
Yes,
that case, don't worry about it, sir. I guess it didn't work. Thank you.
All right, we've come to the end of the day. Unfortunately, we did not complete the process with the transmission panel, so we will resume tomorrow with y'all on the stand to complete questions, commissioners' questions and questions on commissioners' questions. We will be back on the record tomorrow at 9:30. So let's go off the record, please.